This is DB, no?
Any mention?
With your Lordship's indulgence, I beg to mention item number 13 of the hearing list.
13?
13 of the hearing list. Today, actually, I'm a little.
1 second. Yes. You're there, the matter? 13?
Yes, yes, he's there.
He's there?
He's there.
Yes.
Today,
Your objection? Your objection to adjournment?
Yes, Lordship, but I am not, as my Lordship senior is appearing, Lordship, I am not seriously objecting, but from the last few occasions, such a time has been taken, the letter relates to corporation and appointment, and the essence of appointment is time, Lordship. Therefore, Lordship, I am not objecting.
You're appearing for whom?
he's for the bank.
I am appearing for the bank, Lordship.
So he should be more anxious to get the matter done, the petition, the appellant. Then? So you want to give the appointment, then we can order or accordingly.
It will come up as a fixed schedule.
I am not objecting.
Yes.
After vacations?
After?
Vacations?
Okay, after vacation, yes, on the prayer of so and so. Yes.
Highly obliged.
But may I mention a matter not on the list?
Yes, Mr. Goel.
But, what has happened is Assam Rifles has been mulcted with service tax demand of about 20 crores.
Please, can you just keep the voice down? Yes.
Assam Rifles has been mulcted with a tax demand, service tax demand of 20 crores and 10 crores of penalty for 2011 to 2016, and the adjudication order comes to be passed after 9 years. The interest that bears on that is at 18%. So 20 crores of tax demand with interest will probably touch 80 crores or so. My Lord, I'm praying if my Lord can take it up today. It's a very short matter. 7-10 minutes is what I'll take, my Lord.
We opt for the Assam Rifles.
Assam Rifles, my Lord.
But the thing is that has already been filed.
Yeah, it's been filed. E-filed on Saturday, physical filed on Monday. We have informed the other side also.
Other side is whom?
I'm there.
But you're a lawyer for Assam Rifles also.
It's not Assam Rifles, it's a group insurance scheme, it's a private.
Of Assam Rifles, yeah.
Yes, if it's on board, yes. Otherwise,
I'm so glad.
Thursday. Yes. Yes.
Sir, I beg to mention item number 8 and 9, Lordship. Hearing list, Lordship. 2 is Lordship, I pray.
Why? Only that Sheikh.
Lordship was pleased to hear it last week.
The admission, Lordship, matter was fixed for hearing. So 2 weeks, Lordship.
Next week, Lord, if that is the case.
The 2 weeks, Lordship. I have next
Why?
week. I
What
have
is-
little difficulty in next week, Lordship.
Otherwise, it's only the heard, no? Okay. Yes.
8 and 9.
Here's your puja bonus, that's all.
Obliged, Lord.
Yes. Yes.
May I please, Your Lordship? I beg to mention item number 14. My lords, I'm seeking 2 weeks' time for
14
hearing.
Dino Point.
Yes, my lord.
Why?
For hearing, my lord. So we need to prepare some more time, my lord.
Okay, 2 weeks, yes. Apply.
Will you oblige, my lord?
Lordship, I beg to mention item number 15. It's a
Yes.
legal aid matter. Mr. S. D. Upadhyay is having some difficulty today. So let the matter come up after 2 weeks.
Yes.
Much obliged. Item number 1.
So they also will be aware.
May I please, Your Lordship? Lordship, this is an appeal, my lord, against this judgment.
1 second, let the file talk. This is a fresh matter.
My lord, yes, my lord. It's a miscase, my lord. There is a delay of 770 days, my lord. But if we compute the, my lord,
How much? 670 days?
My lord, 770, my
No,
lord.
but then as per the registry, 670.
Yes, my lord. Yes, my lord. If we minus from, because after the judgment and order, we filed a review, my lord. A review was dismissed on 1/5/2025.
Oh yes, 70.
Yes, my lord.
You're right, yes, this was
A review.
slight typographical error here.
My lord.
Lindo. Use Paleko.
My lord, review was dismissed on 1/5/2025, and then, my lord, we filed
Or 1/5/20.
2025, my lord, review, my lord, review petition. Then we filed the instant appeal, my lord. My lord,
Yes, who's appearing?
Lordship, I'll accept the notice on behalf of the state respondents, 1
You
to
have any
6.
objection to coronation?
Private respondents are there, Lordship, 7, 6 and
Then we have to issue notice.
yes.
notice has
7, 6 and 9.
This case number 79/2025. Issue notice. Mr. H. Karmi is present. Accept notice on behalf of respondents.
1 to 6.
1 to 6. Notice to go to our respondent within 3 days. Stop.
My lord.
This after 2 weeks for the orders.
I'll your place.
Item number 5. Hearing. Item number 10.
Lord, 10 and 11, the matter was already heard, my lord. We have to file a written argument. My lord, may kindly give us 1 week time, my lord. We'll file a written argument.
1 week time.
1 week.
Yes, Dr. A.K. Saraf, then Senior Counsel, submits that on behalf of the petitioners, the bullet points are already been filed. However, it's going to place for further 1 week's time. This is the matter after 1 week.
Obliged. 10, 11, similar.
Please, Your Lordship.
1 second.
Lordship. Lordship, we have filed the affidavit bring on record, Your Lordship. Lordship, Leonard Senior is on legs, Your Lordship.
Who's on legs?
Leonard Senior Counsel, Your Lordship.
He's in Shillong.
Lordship. Lordship, I was instructed that Lordship may kindly fix this matter next week, Your Lordship. Any date convenience, Your Lordship.
I have received.
What does it say?
My Lord, the District Council has communicated the state government that the Council has accepted the suggestion given by the Law Department. I will place it, my Lord. It doesn't affect the amending process. Page number 4 of the affidavit.
Page number
4 of the affidavit, Annexure 1. They have got a sub-rule 1 of Rule 92. And that is with regard to the nominal changes by the chairman of the House.
now sub-rule 192.
Yes.
Why the copy is not typed, Mr. Graham?
Lordship.
You supply legible copy. Or it's on next date, lecture 1.
Lordship.
Okay, yes, Mr. Submits that the also affidavit has been filed on behalf of the respondents 327, correct?
Lordship.
When you record letter dated 1/9/2023, showing the 1/9/23 with regard to the amendments that were to be made to the act. However, the copy is not legible. Counsel for the respondent 327 to furnish legible copy on the next date. Just after. Yes.
Well, after a week or so.
Highly obliged, Lordship.
Kawan,
In item 3, can a date be given, my lord?
Take it to the court, Master, Mr. Dutta. See, Mr. Ghosh, there's some slight problem because I think a matter hasn't come yet.
It's on the way, I'm told.
I'm just sending it.
Should be.
As the bench has to break, it'll be after tomorrow. Don't look so apprehensive. The sky won't fall, you know.
It took me 5 minutes to take the matter through. It's on the way.
It's just that all the matters, they've not taken time. No. It's just been filed, Mr. Kera, as per the report.
My lord, yesterday it was filed, it's been numbered.
Yes, it's fine.
Yesterday.
What do? Anyway, you listen on Thursday. Yes.
Thursday may be difficult for me, my lord. Thursday may be difficult for me, just because 4th, my lord, had indicated on the other day, my lord may be busy with the farewell function. That's why we were in a...
See, we can't wait this way also, because we have respective benches also too. Then how urgent the matter?
It's quite urgent because, well, this is a central government.
Doing recovery straight away.
They will, because it's been some time then the order has passed, and I'll tell.
When
my
is the
lord,
order passed?
March.
Oh, then March. Now you've come.
Yeah, I'll tell my lord why. Because what has happened is, I'll tell my lord what has happened. The adjudicating authority has taken 8.5 years to adjudicate. Similar matter, various high courts, Patna High Court, Delhi High Court has given an order that such adjudicating orders after 8.5, 10 years is all bad in law. That's one.
Anyway, Mr. Ghosh, you take a chance on Thursday. Yes. Sorry. Today we're a bit pressed for time. You have taken permission yesterday, or so there's no benches. Yes.
Much obliged, Lordship. Wait, please, Your Lordship. Your Lordship, I beg to mention item number 17, Your Lordship. Lordship, I pray for 2 weeks' time, Your Lordship.
Why?
We need some more time to prepare, Your Lordship, the matter.
No objection, Lordship.
No objection, Lordship.
Yeah.
Lordship, similar prayer for item number 20, Your Lordship.
Why don't you do hearing? I don't understand. Yes.
Highly obliged.
Lordship, I beg to mention item number 21, my lord. If this matter can be taken up next week, my lord.
Yeah, objection, I think.
The region dates are filed, my lord.
They've given a copy of region today.
2 weeks. It's okay.
Yes.
2 weeks.
Please, Lordship. I beg to mention item 18 and 19, Lordship. These are connected matters.
What's the matter about?
It's regarding appointment of a teacher, Lordship. During having some personal difficulty today, Lordship. Kindly have it after 2 weeks.
No objection.
Obliged.
Yeah.
18, 19, Lordship. Obliged.
Grateful.
May please, Lordship. I beg to mention item number 15, Lordship. 13, Lordship. Item 13. Lordship, I'm praying for 2 weeks' time, Lordship. It's a promotion matter, Lordship.
Yes.
Sorry, Lordship. I'm appearing on behalf of respondent number 3.
3 is whom?
3 is MIDC, Your Lordship.
Okay, 2 weeks.
Deeply obliged.
May please, Lordship. I beg to mention item number 16 on behalf of A.H. Karvanna.
Where's H. Karola?
He is in his post, Lordship.
No objection, Lordship.
Yeah.
Lordship.
Supplementary list. Item number 1.
What is this, Mr.?
My lord, here is impugning, my lord, selling the impugned transfer order, my lord, because this transfer order, my lord, this transfer order, my lord, has been in the violation of the policy. The transfer order has been issued in violation of the policy, my lord, and also, my lord, pending inquiry, my lord. Here, just facts, my lord, I was promoted and posted as a commandant of the 67, my lord, 67 battalion of the CRPF at Shillong, my lord. And this order was, I have been transferred only on January of 2024, my lord, 3rd January of 2024, my lord. And I have joined as a commandant by page 15, my lord, 13th of March 2024, my lord, 2024. Now, my lord, before I take to the other points, my lord, page 18, kindly have a look at page 18, my lord, annexure 5. This is the standing order, my lord. This is a policy standing. The subject is transfer policy for Group A gazetted officers, my lord. Now, my lord, will see at page 20 of this policy, my lord, serial number 5. Below, that's a tenure of posting, my lord. May I be permitted to read this, my lord? A. The normal tenure of all the officers under this policy will be 3 years, subject to the provisions of para 5B of this SO. B, my lord, as CRPF is Central Armed Police Force of Government of India, constituted under Special Act, and is tasked with important operational duties regarding maintenance of security of the nation. Therefore, there are certain operational and administrative requirements of the force. In view of such requirements, any officer may be posted to any unit or office at any point of time. The above policy does not create any right for any officer for the posting to a particular place or for a particular tenure as mentioned in para 5A. If during the posting of any officer it comes to the notice of the supervisor senior authorities that officer needs to be transferred out of any time from present place to administrative or operational reasons, then the concerned authority may transfer such officer at any time to a suitable place, my lord. So now, two things is, if exigency require, administrative exigencies requires, or my lord, if there is an operational reasons, my lord, then I can be transferred, my lord. Now can you look at transfer order, my lord? Transfer order is at page 17, annexure 4, my lord. It says that as approved by competent authority, following officers or officials are hereby posted to office unit of the immediate effect as mentioned against each. So my name is number 1, my lord. Now I've been transferred, my lord, to Jodhpur. Jodhpur, my lord. Simple set administration reason. Now I have hardly completed 1 year and 6 months, my lord. There is now, my lord, there is a complaint against me, my lord, and this complaint is an anonymous, my lord, another PIT D, my lord.
What's PIT D?
PIT P, my lord. PIT P is a public interest disclosure and protection of informers, my lord. There's some kind of protection to whistleblowers, my lord. Now, what kind of complaint has been filed against me, I do not know, my lord. Now, transferring me without any reason, my lord, just because some anonymous person has filed a complaint, my lord, and there's an inquiry against me, my lord. This is going to, my lord, number one thing in my humble submission is going to be inquiry is not going to be fair in respect of me, my lord. So it's going to violate my fairness in the inquiry, my lord, because from Jodhpur, my lord, I will be able to contest the inquiry, my lord. And besides that also, my lord,
when is the complaint filed?
My lord, the complaint,
she's written here alleging corrupt practices.
Corrupt practice. Now, what is corrupt practices, my lord? That also is not known to me, my lord. What kind of corrupt practices I have done, my lord? That also not known to me. I'm sorry, my lord.
It will be money only.
Corrupt practices could be money, my lord, could be anything else, my lord, misuse of office. But I myself, my lord, I do not know that what is this kind of complaint, my lord. Now transferring me or at this. And
what happened?
So, my lord, now I have also filed a representations, my lord. Can you look at my
specific comments within 2 weeks? It's been filed the report.
Report has not been filed, my lord, to my knowledge, my lord.
Report is not on record, man. I'll have it but only two things, my lord. Kindly see the transfer order, page 17. Two persons, the commandant and the second to him, my lord, to IC, both have been transferred.
Oh, yes.
Both from 67 BN, CRPF, Shillong.
You mean to say the charges are serious nature.
So there are some problem with both of them, my lord. Commandant and just next to second in command, my lord. So both have been transferred and for administrative reasons very clearly, my lord. Number one, my lord. And number two, the rules itself say, the policy itself says that there is no vested right.
Yes.
And my lord, I have page 24 also, my lord. I have filed a representations, my lord. My lord will kindly appreciate, my lord. At this point, without finding anything, if I've been transferred, my lord, it's going to, my lord, affect the credibility of my service for so many years, which I've built at a good name, my lord. So, my lord, till the next returnable date, my lord, I humbly pray, let this notice be stayed for time being, my lord, till the returnable date. Till they come.
Stay, my lord.
My lord, because if there is no stay, then this petition itself is infractions, my lord.
The policy doesn't support him, my lord.
No, the policy supports me. Policy says 3 years. The 3 years, and only for now, only saying
3
that.
years in normal circumstances.
Yes.
But if exigency demands.
Yes, exactly. That I have no problem if exigencies demands.
You can interfere.
Yes, my lord. My lord.
If
yes.
You know what conditions.
Yes.
If it's penal in nature.
Of course, this is penal in nature. They're saying that there's an inquiry pending against me. Now, during the inquiry, 1 year, 6 months, you are transferring to.
It's nullified.
Malicious. This also is a malicious.
Where you made that statement?
My lord,
where you made a statement that
no, I have made a statement, my lord.
And if it's nullified, you have to make whoever's transferred you by name.
Because this act itself is, my lord, malicious in nature, and then, my lord, sends the very policy, my lord, which says, now anonymous person files and complaint, my lord, which I don't even know. And the inquiry is pending, my lord. At this point of time, my lord, if I get transferred, my lord, kindly.
When you asked to join? Have you joined?
No, my lord, I have not joined, my lord. I filed my representation. The representations are pending, my lord. Page 24 is a representation. This is also pending, my lord. Just till the representations are decided, my lord, if I have given some protections, my lord. Because otherwise, then entire exercise of me filing this becomes infructuous, my lord.
It doesn't, my lord. He can still be retransferred. If he makes out the case, he'll be brought back, my lord, to Shillong.
No, but that too, my lord, that is like unnecessarily putting burden on everybody, my lord.
While giving relief to you.
My lord.
Giving relief to you won't give burden to anybody. Huh?
My lord.
Yeah. Where have you made your allegation of punishment as a punishment or as is malified? You know very well the law regarding transfer.
My lord.
Then?
My lord, D, my lord. Paragraph D, my lord. Paragraph D, page 6, my lord. Arbitrariness and malefides, my lord. The transfer order dated so and so 28 issued by DIG Directorate Central CRPF New Delhi appears arbitrary and malefied without adequate reasoning and may have been influenced by extraneous consideration, rendering it liable to be quashed, my lord.
Well, I'll file affidavit within maybe 3 or 4 days' time, my lord.
Till then, my lord.
But no stay, my lord.
Till then, my lord.
No stay, petitioner. Issue notice Dr. Mbozika with so-and-so's presence, except notice we have all respondents no further notice called for stop. The petitioner has been aggrieved with a transfer order dated
28/8/2025, my lord.
2025 is before this court sealing the same on the ground that the same is in violation of the standing orders dated 27/9/2022 with regard to transfer policy, in as much as the normal tenure posting
is 3 years.
Should be 3 years, whereas the petitioner who has joined only on
January 3rd of March. I'm sorry, March
2024. Sought to be
13th March 2024.
Sought to be transferred by the impugn order. Stop. It is further submitted that
31st January 24. So wrong date.
Okay, January. It's further submitted that the posting or the transfer is purely an extraneous considerations in a notion and on purely extraneous reasons and have nothing to do with the service of the petitioner.
My lord.
Mr. P. Obin also fairly submits that there is a complaint against him, but the same is in the stage of preliminary inquiry, and the transfer and if the petitioner is transferred at this stage, it will deprive him of adequate opportunity to
to participate in the inquiry
and to participate in the proceedings, if any, in further proceedings, any stuff.
Right to fair defense, my lord, to be word.
Dr. Mbozika, senior counsel, on behalf of the respondent, submitted that the transfer policy does not bar such transfers, as if the same is necessary for administrative or operational reasons, the competent authority can transfer the personnel staff. He further submits that in matters of transfer, unless necessary instructions. Yes. Having heard the counsel of the parties, at this stage, no interim orders are called for. This after 3 days. You will list it on
Monday.
List on Friday.
Friday, my lord. Till then, status quo be maintained, my lord. Kindly, my lord.
On Friday. There's no date for you to join. If there's any date for you, as you report a certain station, it's not there. Well, it's already been affected. You don't know. Yes.
Daily list item number 1.
It's on Friday for instructions. I believe.
My lord.
Where are you?
My lord, can it be on Monday, my lord, Friday? Of course, some matter. My lord, obliged.
My lord, in the last occasion, Lordship has given me time to file application to correct the cause title. And we got the impression that the respondent number 15 is not represented by any lawyer. I came to know that my friend Mr. Sheikh is appearing for respondent number 15.
Why don't you clarify this before?
But I'm so sorry. That only. Since my friend is appearing, if Lordship permits me to take up next week or other week for hearing, madam. And my friend was not there on that day because of that.
I got pass order which case?
My lord, this was passed in item number 5, my lord. In item WPC
445.
Excuse me. Let me see the shit.
But the private respondent number 15 title was wrongly mentioned instead of mentioning Islam. We have mentioned Hussein, that confusion arose. Therefore, we thought
Yes,
that.
Mr. Chairman, also today submits that due to inadvertence, he was under the impression that respondent 15 was not represented in the matter. He submits that he has now come to learn that Mr. S.A. Sheikh would present court to reference respondent 15. And in those circumstances, the order dated 14/8/2025 hereby recalled, and the matters fixed for hearing after 1 week. Unnecessarily, Mr. Chang. So
yes, this is so sorry.
Here's the whole matter.
Right. Sorry.
My lord, item number 1, 2, 4 and 5 are connected matters.
Just together with this one. 4, 5.
Item number 3.
We have taken steps on the newly pleaded respondent, my lord. NPCI.
Yes, they've taken steps. MS Adata submits that steps have duly been taken on the newly implicated respondent number 6. On
21st.
On 14/8/2025. However, often indicates that the AD cards not yet received. According to this, after 1 week. Yes. Meantime, Petitioner is also allowed to verify the status of service.
Item number 6.
Please, Your Lordship. Lordship, I may be allowed to withdraw this petition, my Lord, with the liberty to approach the appropriate forum.
This is which matter?
This is NCC, my Lord. This is in regard to performance bank guarantee, my Lord.
Okay, yes, Mr. AG Movement stays without to withdraw this matter. Will it be to approve to seek alternate remedy?
Lordship.
In accordance with law.
Lordship.
On the prayer, seeing the prayers allowed, the petition is closed on withdrawal with liberty granted as prayed. With liberty as prayed.
Hello, Prashma.
7.
My lord, I have filed a report on the 29th of August, my lord, bringing the latest status report of the cases pending, my lord. Lordship, may kindly have my report, my lord. Well, the first page is the index of the numbers of cases which are pending, my lord. Lordship, the first box is with regard to East Khasi Hills, my lord, that is Annexure A. My lord, in Annexure A, my lord, so far as East Khasi is concerned, we have 3 cases. And Lordship, among these 3 cases, one is pending before the High Court, my lord, and one case, my lord, that is at page number 3, my lord. In that case, so far as page number 2, my lord, the first case, the status remains the same. And number 2, my lord, that is page number 3. My lord, in comparing to the earlier report, my lord, 3 witnesses have been examined, my lord. So before it was 23, my lord, now there's 17, my lord. So remaining witnesses are 89, my lord. So 3 has been examined recently. And my lord, the page number 4 is East Khasi Hills. As I said, this is with regard to the matter pending before the Honorable High Court, my lord. My lord, Annexure B, my lord, West Garo Hills. In these cases, Lordship has directed that if a clear picture may be produced whether these cases are pending. So, my lord, and there are 2 cases pending, my lord, and in annexure, in so far as West Garo Hills concerned, my lord, may kindly have page number 6, my lord. Yes. Page number 6 is the case number, my lord, at the bottom. That is criminal special PC under PC Act, my lord. 1 case is pending before the High Court, and the order is at page number 7, my lord. My lord, that is the first order in which a stay was granted by this Honorable Court, my lord. That is 6th of June 2025. Yeah. And Lordship, at page number 9, I have placed a recent order of August, my lord, in which the stay is still operating, my lord.
Yeah.
And my lord, page number 10, that is the second case. 11, my lord. That is the second case. And in this respect, my lord, I have enclosed the order at page number 12. So this is 1st July, my lord, where stay has been granted, my lord.
Yes.
And the recent order is at, then continuing order, my lord, is at page number 14, my lord, in which stay is still operating, my lord. And the case number is also indicated, my lord, at the bottom. The entire proceeding to be kept in abeyance, my lord. So these orders are operating, my lord, which is why the matter before the West Garo Hills Court, my lord.
They have been stayed.
My lord, yes. And my lord, annexure number C, my lord, that's page number 15, that is in respect of West Gentia Hills, my lord. There's only 1 case pending in West Gentia Hills, my lord, and as per the, my lord, report submitted, my lord, by the PP, additional PP. So, my lord, this case is also on the verge of completion, my lord, at the stage of evidence, my lord, because there was a supplementary charge sheet filed, my lord, what he has stated in 2025. So, it's for further evidence, my lord.
A status report dated 29/8/2025 has been filed by the learned government advocate. Perusal of the same shows that in East Khasi Hills, 3 out of 3 cases are still pending. 2 before the judicial magistrates, before the criminal courts, and 1 before this court. Is the application of 482 before the court?
My lord, yes. Yes.
482. In the as far as West Garo Hills is concerned, wherein there are 2 cases, both these cases are now before this court, wherein interim orders are operating, suspending the trial in the meanwhile. As regards the single case pending in West Gentia Hills, it is seen that it is at the stage of.
My lord, these are, lordship, meant to the court before the Honorable High Court, my lord. Garo Hills cases.
The last case.
My lord, this is at the stage of further evidence, my lord.
Since evidence.
My lord, if lordship will have the report, my lord, of the PP, he says, and my lord, on 12 August 2025, a supplementary charge sheet was filed, which is why the evidence has to continue further, yes, my lord.
And the same is continuing as supplementary charge sheet has since been filed. In all, in this next file, I've seen that the 6 cases in the state are still, or the 6 cases are still pending, just after 8 weeks for further report. Yes.
Item number 8.
Please, your lordship. Lordship, pleadings are complete, your lordship.
Yes.
Pleadings are complete. Respondent number 6 and 7 have filed the affidavit, your lordship.
What do you want?
Let's the matter fixed for hearing, your lordship.
State's filed. We have filed long back. You won't file rejoinder?
No, Your Lordship.
Yes, counsel submit that the proceedings are complete and no rejoinder will be necessary. This is matter for hearing after suit.
9.
Much more.
Which other is
Please, Your Lordship.
Yeah.
Lordship, this matter we have received the instructions and we'll be filing the rejoinder, Your Lordship.
How many times you sought for rejoinder?
This should be the second time. First day.
Second time?
Yes, Your Lordship. 1 week, Lordship.
You all filed?
Yes, Your Lordship.
Do all affidavits for rejoinder?
Filing, Lordship.
Yes, Mr. Hong Snee, Leonard Counsel Petitioner, submits that rejoin on that.
Your rejoinder?
Further 2 weeks' time is required.
One week, Your Lordship.
1 week.
Your Lordship.
To the affidavits filed by the respondents 1 to 4. Just up to 1 week, yes.
Much obliged.
10.
May it please Your Lordship. Your Lordship, this matter is regarding the pensionary of a disabled person, my Lord. So, my Lord, a wide order dated 087/2025, my Lord, has passed an order that the respondent is supposed to release the benefits within 6 weeks, my Lord. But till now, my Lord, there is no...
Where's Mr. Debnath?
My Lord, none has appeared, my Lord.
Where's Mr. Debnath? You file contempt. Today when the matter is taken up, there is no representation on behalf of the respondents. There are counsel for the petitioner, next para, the petitioner has drawn attention to this court to the order dated 8/7/2025, where directions have been issued that the process for the pension should be completed within 6 weeks. Submitted by the other counsel that till date nothing has happened. Accordingly, since it will be listed tomorrow, tomorrow is.
Highly obliged, my Lord. Obliged, my Lord.
You inform him?
Yes, my Lord. I'll definitely inform him.
11.
Please, Lordship. This matter is listed today for hearing on immateriality, so the state has to open the arguments.
Yes,
Your Lordship, I'm praying for 2 weeks' time, Your Lordship. As the Learned Advocate General is having some personal difficulties.
Where is he?
He is in the Supreme Court.
Minority, why?
They're saying we have a recourse under Section 64.
So you oppose that?
I oppose that.
Why?
Lordship, for reference to be made under Section 64, the language of Section 64 read with 77, the award has to be present, but in this case the award has already been disbursed. So for reference to be made, the award has also to be deposited before the collector.
You mean to say the compensation has already been disbursed?
Disbursed. Admitted fact.
There's no counsel, what you call backup counsel to these matters.
It can come after.
Yes. What amount released to Swan 5? What amount released?
Around almost 4 crores, Your Lordship. So our petition is only for recovery of that amount, and we're willing to go for 64 as well. That's been our, even when we file our objections, we've referred for 64.
Already withdrawn the amount?
Already withdrawn the amount.
Then, who is that lady? This is a lady or a...
Florid Nongsam.
Oh. No, the matter is fixed for hearing on the maintainability of the petition today. MS Aslan on behalf of the Leonard GA pay some accommodation due to the absence of the Advocate General in consideration of this after 1 week here.
Hearing. Supplementary list item number 2. Supplementary list item number 2.
What to do, Mr. Muzika? Dr. Muzika?
Well, CRPC doesn't permit, my lord.
Then what? Yesterday, because you're not here, so the court's asking the counsel for the respondent. Show the way to the court. Show the way so we can lighten the burden.
But I am also not. But when the CRPC is not permitting, my lord, that is where. Otherwise, I wouldn't have opposed. Looking at the age and the health conditions, my lord. But law is not permitting.
Can we make an order that it will not be preceded in the criminal matters? When it's 6 months imprisonment, correct?
Yes, Your Lordship.
They can bring one small decision also, my lord.
Your Lordship.
They have tried.
I have. Yes, Your Lordship. Your Lordship, only on the mitigating circumstances, on the age.
Yes.
On the age and health conditions of the respondent, Your Lordship, and this may not be acted as a precedent, Lordship. Under 226, this honourable court has ample power, Lordship.
That's why I say show an authority.
Your Lordship, if you could come to page 83 of the writ petition, Lordship.
83?
Yes, Your Lordship, the last page.
There's only window, so this is available, my lord.
Because, Your Lordship, this was also taken in one of my in my reply, Your Lordship.
83?
83 of the writ petition.
Last page.
The last page of the, yes, Your Lordship. The below bottom part, Your Lordship. This court has suggested that considering the age, yes, Your Lordship. I'll read from the top. The accused person so-and-so is present along with her counsel so-and-so. Learned PP for CBI, Shri so-and-so is present. The accused so-and-so had filed application under section 265B CRPC for plea bargaining. The accused has charged with an offence under section 13.2 read with 13.1D PC Act read with section 419 420 IPC. In working out a mutually satisfactory deposition, the accused was explained about the punishment that she has prescribed for the offence committed by her. The prosecution submitted that the instant case relates to cheating the government and obtaining undue pecuniary benefits, and the court may proceed in accordance with section 265E CRPC, and she may be awarded the minimum punishment prescribed for the offence. The accused during the meeting had admitted that she had committed the offence and is ready to face the consequences, and agreed that she may be awarded punishment as prescribed. This court has suggested that considering the age of the accused and her health conditions, she may be sentenced to pay a fine of ₹50,000 and to undergo simple imprisonment in lieu of the minimum punishment for the offence. Next line, the parties have agreed to the suggestion of the court. The report may be placed before the court. Your Lordship, here the counsel for the CBI also agreed, Your Lordship. This is the, he agreed that instead of minimum punishment, instead of the punishment prescribed under the Act, I may be given minimum punishment. And thereafter, sorry, Your Lordship, that day itself, yes, sir. That day itself, and the punishment also to stand in the court for the whole day also, where that was done. And that time the PP could have placed the objection here in this report that I'm asking for this as punishment. He did not.
Dispose of the 3-line order. Not avoid any interpretation at all.
Only that this will not become precedent also.
It may not be acted as precedent.
Kick down. Excuse me. The instant writ petition have been preferred against the judgment and order dated 7/7/2023, passed by the learned court or a special judge bracket CBI so long stop briefly put, in the proceedings before the trial court, the respondent had filed an application under section 265 CRPC for plea bargaining, and accordingly the prosecution bracket CBI expressed that they were ready for a procedure of plea bargaining. Plea bargaining stopped. Thereafter, in the said proceedings, the respondent had admitted that she committed the offence and also was in agreement to be awarded punishment as being prescribed by the court. Stop. Learned Court of Special Judge, considering the age and health conditions of the respondent, had suggested that she may be sentenced to pay a fine of rupees 50,000 and to undergo simple imprisonment. Stop. The suggestion as put forth by the special judge, special court, by the Court of Special Judge, was then agreed by the parties. It appears due to the special circumstances surrounding the condition of the petitioner. Stop. Next paragraph. Thereafter, by the impugned judgment and order dated 7/7/2023, the learned special judge convicted the respondent under section 419/420 IPC, read with section 13(2) of the Prevention of Corruption Act 1988, and sentenced the respondent to undergo simple imprisonment till the rising of the court and fine of rupees 50,000 only. Stop. Next paragraph. The respondent, it appears, had accordingly paid the fine, and after being admonished was released thereafter. Next part, this writ petition has been preferred. It appears on the ground that the sentence was not in accordance with the mutual, capital M, satisfactory disposition. Next paragraph. I've heard and counsel, this court heard the counsel parties and also examined the materials on record. The impugn order it is seen was the accused stroke respondent, as per report, is what's the age?
70 years now at present.
Is 70 years at present, and is also suffering from
Hypertension and blood.
Suffering from old age ailments like hypertension and so forth.
Which is
it's also for approval of the impugn order shows that the consideration given by the court was basically on these grounds of advanced age and ill health, which perhaps would have made the respondent unfit for imprisonment as prescribed by law. In consideration thereof, without further dwelling to the facts, the no interference is called for by this court with the impugn order dated so and so
7/7.
Yes, and the matter is accordingly disposed of. Next paragraph is made clear that the observations or the findings in this matter shall not serve as a precedent in any other matter. Will not make any.
Yes, Lordship comments. Yes. Deeply obliged, Lordship.
Deeply.
Item number 12.
I won't take long, my lord. I will summarize my argument. Now, the core of the issue.
That sounds very.
Because, my lord, I want to finish it up.
That sounds very.
I want to finish it up because, my lord, the difficulty is, unfortunately, the petitioner in this case, my lord, now she has been diagnosed with cancer. I want to finish the case. She is under lots of agony and pain. So, one way or the other, let this matter be over, my lord. This is what I wanted. Yes.
My lord's senior counsel will be joining us through
Yes,
VC.
he is very much. He has already joined.
He's there.
Yes, your lordship.
My esteemed colleague has already joined. Now, my lord, to be brief, my lord, what exactly is the core of the issue?
Yes.
The core of the issue is, my lord, the petitioner, when she was serving in City College, Calcutta, her salary was paid by the government of West Bengal. She was covered by the old pension scheme. She moves from City College, Calcutta to Nehu. Now, after she moved to Nehu, now, my lord, the two major issues arise. Number one, whether the services rendered by the petitioner in City College, Calcutta, whether that period should be counted towards her pensionable service over here. That's point number one. The second point will be whether she will be covered by OPS, old pension scheme, or she will be covered by the new pension scheme. Nehu has taken a stand that she will be covered by the new pension scheme.
Yes.
Now, my lord, ultimately, my lord is familiar. We are governed by the office memorandums of the Government of India, Department of Pension. The office memorandums, my lord, have outlined two categories. Movement from central government or central government autonomous bodies to state government or state government autonomous bodies, or vice versa. Now, my lord, in open and shut cases, there is no difficulty. Problem only arises, and that is how, my lords come into picture, when it is not neither black nor white, there may be a little bit area of grey. Possibly, my lord, at the most in this case it may be said, here, my lord, we are dealing little bit of grey area. To begin with, my lord, the first question would be, what is City College, Calcutta? What is the legal status of the City College, Calcutta?
The private college.
I'm dealing with it. I'll answer this question. And the second part would be her conditions of service in the City College, Calcutta when she was there. Now, first come first, my lord, the legal status. The legal status of City College, Calcutta.
First is whether services rendered in City College can be counted towards her necessary benefits.
For that, we have to answer the question.
Number two, whether it was counted under old pension or new pension scheme.
Yes, that's it.
Okay.
These are the two issues. Now, my lord, to answer this, the first issue will be what is the legal status of City College, Calcutta. The second aspect would be the conditions of service of the petitioner when she was in City College, Calcutta. So, on the legal status of the City College, Calcutta, my lord, I have prepared a small note. Where is please? It has already been passed on to my esteemed colleague in Calcutta. Is there? Lordship may kindly have a look. A small note for my lord's benefit.
Here.
I'll just read this note, 1.5 page only, around 2 pages. The City College is a government-aided educational institution administered by the Brahmo Samaj Education Society. The government of West Bengal introduced West Bengal College Teachers Security of Service Act 1975 and the West Bengal College Service Commission Act 1978. And my lord, these two legislations, they vested in the government of West Bengal the power to appoint teachers and enforce discipline among them in the government-aided educational institutions. So these two legislations were important. Now, provisions of the said regulations were challenged by the BSES, that is BSES stands for the Brahmo Samaj Education Society. The Brahmo Samaj Education Society challenged the provisions of these legislations in a writ petition before the Supreme Court, claiming that being a religious minority within the meaning of Article 25, 26 and 30 Clause 1 of the Constitution, it alone has the right to appoint teachers and enforce discipline among them, and as such it prayed to prohibit the state of West Bengal from enforcing the Security of Service Act 1975 and the College Service Commission Act 1978. Not over here in Assam, we have this provincialization act, we call it. Over there, my lord, the government of West Bengal brought the City College, Calcutta within the purview of these two legislations, and Brahmo Samaj Education Society challenged it. The Supreme Court examined the issue in the light of its earlier decisions in TMA Pai Foundation versus State of Karnataka, and by its judgment dated 5/5/2004, reported in 2004-6 SCC 224, Brahmo Samaj Education Society versus the State of West Bengal allowed the writ petition, holding thus in para 7 of the judgment. And my lord, quote, I read this: only a person who has qualified NET or SLET will be eligible for appointment as a teacher in an aided institution. This is the required basic qualification for a teacher. The petitioner's right to administer includes the right to appoint teachers of their choice among the NET, SLET qualified candidates. So, my lord, the Supreme Court said Brahmo Samaj Education Society not only has a right to administer its institution but also has a right to appoint the teachers. Now what happens? The state of West Bengal preferred a review against the said judgment on the ground that the observations made by court in para 7 of its judgment are contrary to what is held in para 72 of TMA Pai Foundation case. Now, my lord knows very well TMA Pai Foundation, my lord, is the Constitution Bench judgment. The Supreme Court, it should be typographical error. The Supreme Court, by its order dated 31/7/2008, reported in 2020-17 SCC 218, allowed the review petition, recalling its earlier judgment, and placed the writ petition to be reheard by a Constitution Bench. The Constitution Bench considered the issue and in its order dated 15/1/2016, reported in 2020-19 SCC 708, allowed the BSES to withdraw its writ petition to enable it to approach the central government for a declaration to the effect that Brahmo Samaj is a minority religious community. Now, my lord, the reason being because Brahmo Samaj was claiming itself a minority status. The Supreme Court took a view: if you are claiming that status, central government or the state government, they are the competent authority. So you go before them, you get the recognition from them. Who are we to decide as to whether you are minority or not? It was directed that during the interregnum, the interim arrangement made by the court in terms of its order dated 2/4/84, which continued by subsequent order dated 31/7/2008, passed in review petition, shall continue for a period of 1 year. The said interim arrangement was in the following terms. We direct that the West Bengal government will pay the salaries to the principals, vice principals and teachers of the institute run by the Brahmo Samaj Education Society, provided that the appointments to these posts are made by the institutions concerned in accordance with the provisions of the West Bengal College Service Commission Act 1978, quote unquote. The Supreme Court also made it clear that if the central government does not receive the representation from the BSES within a period of 8 weeks from the date of order, the interim order shall stand vacated without any further reference to the court. The Constitution Bench accordingly disposed of the writ petition as withdrawn, granting liberty to the petitioner to approach the central government. The central government Ministry of Minority Affairs, because BSES may not then approach the central government. The Central Government Ministry of Minority Affairs, while its letter dated 36/2017 held that the Brahmo Samaj Education Society is not a religious minority at the national level, but allowed the Brahmo Samaj Education Society to approach the state government for minority status. Accordingly, the society approached the state government seeking minority status. The state government, by its order number such and such dated 8/9/2017, decided the application of the society, holding that the Brahmo Samaj is not a minority religion and the society does not enjoy the minority status. Consequently, the government of West Bengal, by order number such and such dated 3/11/2017, Milord, copy is enclosed. Lordship may kindly, I am giving that copy of the order. My esteemed colleague over there has the copy of the order. Please kindly give it to Subi. So I'll just read the paragraph 10, then Lordship may see this order of the government of West Bengal. Consequently, the government of West Bengal, by order number such and such dated 3/11/2017, held that the colleges administered by the BSES should be treated as non-minority government-aided colleges, and the governing body of all the government-aided non-minority colleges shall have to be constituted in terms of the provisions of Section 4 and 5 of the West Bengal Universities, Colleges, Administration and Regulation Act 2017. So this is it, and Lordship, my Lord, has seen the order. I'll just, my Lord, point out,
but once
the entire history is narrated.
I mean, the merits of this case aside, now what is this authority in Calcutta that decided? But isn't it, do they have a minority commission in?
They have the commission. That is how they decided it.
But this has come from the minority commission.
But not after the decision.
Yes.
Let my esteemed colleague wants to say something.
Yes.
No, it has not come from the minority commission.
Order is of the government of West Bengal on the basis of.
It is of the government of West Bengal, and the order is dated 2017.
Yes.
Now, this matter pertains to an issue which has been considered before the Lordship for the year 2007. And prior to that,
oh,
the petitioner joined the City College way back in the year 1998.
Oh, that's all right. I'm dealing with the facts. There is no difficulty. I'll deal with the facts. I just wanted clarification on this.
Joined Nehru in the year 2007.
much before all this happened. Yes.
My Lord, that should not. I'm sorry. I'm not yielding, sir. Please let me complete my part. My Lord, that would not be any. That would not create any difficulty. If I am not a minority, I am not a minority, and that has retrospective effect. I am not a minority. I was not a minority at any point of time, regardless of the fact as to when the declaration is made. My Lord, the principle is. I'm sorry, sir. Sir, please, sir, allow me to complete myself. I have not completed my submission.
No, on a query of the court.
My Lord, it's like that. My Lord, let me explain what the law is.
Whether a declaration that is not a minority religion or institution has been given by the competent authority, or but then he's kindly said that no, it's done by the education department. Let's continue from there. Yes.
Let me explain.
No derailment.
The fact of the matter is,
yes,
the Brahmo Samaj has not been recognized as a minority religion, and the school does not enjoy the minority status. This is the position as on today, and that was the position even earlier. It would remain the position. My lord, the effect is like what? Imagine a situation when the judgment of the court, by judgment of the court, a particular statute is held ultra vires or a particular action is held illegal. Whenever a statute is struck down by the honorable court, holding it unconstitutional, unless the court exclusively says that it has prospective effect, the law travels backward with retrospectivity. It is illegal for all time to come. Over here, my lord, earlier there was no recognition. It is Brahmo Samaj is a religious minority. Merely because such a position became clear in 2017 does not mean it was a minority institution earlier. It could not have been, because there was no legal basis to claim that BSES is a minority religion.
Please proceed from there.
So, my lord, school at no point of time enjoyed a minority status, and Brahma Samaj Education Society cannot be treated to be a minority, my lord, society. This is the legal position. Please.
Okay, yes.
Now, my lord, please, what do you want to say?
एजुकेशन डिपार्टमेंट में पास किया है, उसमें कंफ्यूजन है.
ठीक है. Lordship will see, my lord, so far as to from whether there is any declaration from the Department of Minority Affairs, my lord, that my lord will find the reference is made to that in the second page of the order dated 3/11/2017. I'll just read, my lord, from the last paragraph of the first page. Order dated 3/11/2017.
Yes.
I just read, whereas the said society, the last paragraph, order dated 3/11/2017, whereas the said society under the banner of Sadharan Brahmo Samaj has applied before the state government seeking minority status. See, my lord, this answers my lord's question, and their application has been considered by the state's minorities commission. While at the same time, the Sadhana Brahmo Samaj has filed a writ petition before the Honorable Calcutta High Court seeking a direction upon the state government to dispose of their application pending before the state government in WP number such and such. And whereas the Honorable High Court was pleased to direct the state government, while disposing the said writ petition, to dispose of the application of the said society within 3 months, and the state government in the Department of Minority Affairs and Madrasa Education Department has finally decided their application by clearly declaring that Sadharan Brahmo Samaj is not a separate minority religion while their order number such and such. And whereas it is now thus settled that the said society is not a minority administered society, and therefore the colleges administered by them should have been treated as non-minority government aided colleges, and therefore cannot get the benefit of the provisions of Statute 100 of the first Statute of Calcutta University. And whereas after enactment of the West Bengal Universities and Colleges Administration and Regulation Act 2017, the provisions of Statute 100 of the Calcutta University First Statute have become redundant, and the governing bodies of all government aided non-minority colleges shall have to be constituted in terms of the provisions of Section 4 and Section 5 of the above mentioned Act. And whereas it is expedient that the existing government bodies of all the colleges administered by the said society, which were constituted in terms of the provisions of Statute 100 of the Calcutta University First Statute, shall not continue to function in contravention to the provisions of the West Bengal Universities and Colleges Administration and Regulation Act 2017, and therefore those governing bodies are liable to be dissolved. Governing bodies are liable to be dissolved, and therefore, in consideration of the above, the governor, in exercise of the powers conferred under subsection 3 of section 4 of the West Bengal Universities and Colleges Administration and Regulation Act 2017, is hereby pleased to direct that the existing government bodies of 8 government aided colleges, which also include City College Calcutta, as mentioned at paragraph 2 of this order, shall be dissolved with immediate effect. The Vice Chancellor, Calcutta University, and the principal stroke teacher in charge of each college is hereby directed to take steps to reconstitute the governing body in terms of the provisions of the West Bengal Universities and Colleges Administration and Regulation Act 2017 within 3 months until such time when administrator shall be appointed by the state government under section 4 of the above mentioned act to perform the duties of governing bodies of respective colleges. So, my lord, at the time when the administrator was appointed, separate orders will be issued for appointment of the administrators in 8 government aided colleges as mentioned in paragraph 2 of this order. So, my lord, on the basis of this, now I submit. In 98, when the petitioner joined the City College Calcutta, and when she left City College Calcutta, the position is she was serving in a government aided college which was not a minority institution. Now, my lord, I'll take your lordship to some of the provisions of the West Bengal College Service Commission Act 1978. Some of the provisions I'll take your lordship to. Now, this, my lord, will find, I'll just, my lord, there is an extra copy of the lordship may have the 1978 Act. Yes. Sujit, you have? Sujit? I'll give you. '78 Act. Lordship may see Section 3. Section 3. Subsection 1. The state government shall, with effect from such date as it may by notification appoint, constitute a commission by the name of West Bengal College Service Commission, consisting of 7 members, of whom 1 shall be the chairman. Section 4, subsection 1. Appointment and terms and conditions of service of members. The chairman and other members shall be appointed by state government in consultation with the chancellor of the universities referred to in clause Q of section 2. Then lordship may turn to functions of the commission, section 7. Just some of the relevant sections I am referring to. Section 7, subsection 1. Notwithstanding, it begins with the non-obstant clause. Notwithstanding anything contained in any other law for the time being in force or in any contract, custom or usage to the contrary, it shall be the duty. It shall be the duty of the commission to select persons for appointment to the posts of teachers of a college. So teachers are appointed by the commission. Section 8, subsection 1. The manner of selection of persons for appointment to the post of teachers of a college shall be such as may be provided for by the regulations. Section 9. Effect of recommendation of the commission. Notwithstanding anything contained in any other law for the time being in force or in any contract, custom or usage to the contrary, appointments to the post of teachers of a college shall be made on the recommendation of the commission. Only on the recommendation of commission, the teachers will be appointed. Then section 9 capital A deals with eligibility, the test that will be conducted. The heading is Commission to hold eligibility test of persons before selection for appointment to post of lecturers in universities and colleges. 9 capital A. I'll avoid reading it below. This is the core. So practically below the selection, yes.
You set out the law.
Proper selection. Then Milord, protection of teachers, section 10. Notwithstanding anything contained elsewhere in this act, the terms and conditions of service of teachers of a college in the employment of such college immediately before the commencement of this act shall not be varied to the disadvantage of such teachers insofar as such terms and conditions relate to the appointment of such teachers to the posts held by them immediately before the commencement of this act. Then section 15. Subject to the provisions of section 9 capital A, nothing contained in this act shall apply in relation to any college not receiving any aid from the state government or any college established and administered by a minority, whether based on religion or language. So college not receiving aid or the minority institution, they shall not be governed by it. Section 16, the state government may by notification make rules for carrying out the purpose of this act. Then my lord, section 17, the commission may with the previous approval of the state government make regulations. So regulation will be made by commission with the previous approval of the state government, not inconsistent with the provisions of this act or the rules made thereunder for discharging its functions under this act. Then my lord, subsection 2 of section 17, in particular and without prejudice to the generality of the foregoing power, such regulations may provide for all or any of the following matters. And my lord, this is important. Lordship may see, my lord, what regulations may provide for. A, the terms and conditions of service of the employees of the commission under subsection 3 of section 6. B, the manner of selection of persons for appointment to the post of teachers of a college under subsection 1 of section 8. And D, Lordship may see, D, I'm sorry, D, the manner of holding eligibility test of persons who are candidates for appointment to the post of lecturer in any university or institution deemed to be a university or college or government college prior to the selection of such persons by any authority competent to make the selection of such appointment under any law for the time being in force under subsection 1 of section 9 capital A. So my lord, this is West Bengal College Service Commission Act 1978. Now my lord, this was amended also in 2012. I have also gone through the amendment. I have got the amended copy, and my lord, substantively the provisions have remained the same. I can give you the copy of those amendments, 2012. I'll furnish it, my lord. There is no substantive change in the position. Now, my lord, I'll take your lordship to the second legislation. Two legislations I'll deal with.
Yes.
The second legislation is, my lord, the West Bengal Universities and Colleges Administration and Regulation Act 2017. This, my lord, will find, my lord, in the, it is there, my lord, in our affidavit, but I have annexed it, my lord, with the relevant enclosures. That is, my lord, I had given your lordship 3 compilations. One of the compilation was the basis of petitioner's entitlement. The heading is, the heading of that compilation is basis of petitioner's entitlement. Whether my lord has, it was given to my lord.
Dates, that's all.
Was it given to the honorable court? My lord, one more copy we are furnishing.
Well, I have this.
Only one?
Yes, only this.
Only one was
That's
given?
the list of dates. No, that we don't have. It's not been given before. We have list of dates and brief facts.
My lord, that was also given.
No, that's not given.
You might have made a mistake.
No, it has not been given. It will be here in the record.
I'm giving it. So, Sujit, you got it? The basis of petitioner's entitlement, yes, it is there with my learned colleague. We furnished it to them also, the other side.
Never mind, yes.
So, my lord, lordship may, for our benefit, I'm sorry, my lord, but lordship may write numerical number 2 over here. It is the second compilation. It ought to have been numbered for benefit. It will be easy. Now, here, my lord, will find page 19 of this compilation. It is, my lord, 2017.
Yes. The act which my learned friend is referring to now has neither been mentioned in the writ petition.
No, my lord, this I'm quite amazed by this kind of submission. My lord, this is the position of law. No, this is law. It's such technical argument as if, my lord, we are not seeking.
Please. You're both senior counsels. Let's be. Yes.
I am not seeking any relief against West Bengal. Why are they worried? Creating, my lord, unnecessary. My lord, just a minute.
Please.
My lord, it is annexure 3.
Yes, what do you want to say?
My lord, it is annexure 3 and affidavit in reply.
Yes, please. You say that this document was never enclosed in the writ petition, number 1. Is that correct?
It is not in the writ petition, it is our affidavit in reply. Annexure 3, page 32 to 40.
So what relevancy does this act have?
Relevance, Lordship will find now. In the compilation itself, my Lord may see in the list of dates. 22/3/2017.
Yes.
Section 2. My Lord, is the brief. I have summarized all the relevant sections in brief.
Government West Bengal
yes.
abuse West
The
Bengal
internal page 3. Internal page 3 of this compilation, section 2, Lordship may have a look. Section 2 of the Act makes it applicable to all colleges receiving financial assistance on a regular basis from the state government through the pay packet scheme. Under section 10, subsection 1, my Lord, I am avoiding reading the section, just I am giving the summary of that. Under section 10, subsection 1, appointment of all teachers and other employees of every college shall be made by the governing body on the recommendation of the Service Commission. Under section 10, subsection 4, the terms and conditions of service, including the manner and procedure of holding disciplinary proceedings and punishment thereof, all the employees of the colleges shall be such as may be prescribed. This is important, my Lord. Section 10, subsection 4. The terms and conditions of service, including the manner and procedure of holding disciplinary proceedings and punishment thereof, all the employees of the colleges shall be such as may be prescribed. So, my Lord, this is by the mandate of the legislation. Under section 11, subsection 2, the state government has the authority to place the service of any teacher or non-teaching employees to another college on transfer. So, state government is vested with the power of transfer also from one college to another, along with the discipline. Under section 18, the state government has the power to give direction to any college in any matter not inconsistent with the provisions of the Act, and the college shall be duty bound to comply with such direction. Under section 17, the state government has the power to make rules in relation to terms and conditions of service of all employees of colleges, code of conduct and discipline for all the employees of colleges, manner and procedure for holding disciplinary proceedings, manner and procedure of transfer, manner and procedure for maintaining funds, such other subject as the state government considers necessary. So, my Lord, very, very wide powers. Practically, my Lord, just like in Assam, my Lord, we have the provincialization. It's like this, the college is there, but teachers are totally under the state government control, completely, for all intent and purpose.
The provincialization is different.
Yeah, different, but my Lord, ultimately,
yes.
my Lord, what I am trying to, my Lord, Lordship has understood my line of argument. What I would like to demonstrate.
The conditions of service, the pay.
Yes.
The pay
Number one,
service, that's all.
Number one,
Yeah.
whether the kind of, who was paying your salary, and whether your service was a pensionable service. From where your salary was coming. Whose employee you were. Lord, it stands to reason. It stands to reason. The person who controls me is my employer.
Okay,
Who
yes,
controls
please,
me? Discipline,
yes, please.
transfer, salary, everything, my Lord, is controlled by the state government.
Okay. That's all.
So, my Lord, this is it. Now, my Lord, straight away.
Yes.
Now, my Lord, I will turn to the office memorandums. Thereafter, I will come to the basic facts.
I thought we were done with the basic facts.
My Lord, ultimately, how I moved from City College to Nehu.
That is why you sounded very ominous when you said that. I'll make my argument very brief.
I'll be brief there also.
Ominous.
My Lord, but I have made the job of the Honorable Court bit easy, my Lord, by giving the list and relevant events.
Court very happy, thought that maybe this is a concise submission and
yes,
it's over. Waiting for authorities.
But my Lord, with such if my submissions are so short, my Lord, it would be very easy for my Lord to dismiss my case. I would not like to I would not like to make the job of the Honorable Court so easy.
But like my old seniors who say, the longer the arguments, the weaker your case is.
It all depends upon nature of case. We have all learned this in course of time.
Yes.
We have learned it in course of time. It all depends upon nature of case. What is important is arguments must not be repeated. Whatever point we make, we must not repeat those points.
Okay, please continue.
So, now the office memorandums. The office memorandum, The office memorandum, my lord, I will just rely on two office memorandum. The most relevant will be 11/6/2020. This, my lord, will find enclosures with regard to notifications of the Government of India. All the notifications in one compilation we have given. They are all part of the writ petitions. They are part of the writ petitions. The office memorandum I am referring to is annexure 15 of the writ petition dated 11/6/2020.
Yes, okay.
In the compilation, it is page 5 to page 7.
Yes.
My lord will see just page 5 itself. Issued by Ministry of Personnel, Public Grievances and Pension, Department of Pension. The undersigned is directed to say that the new pension scheme, now called as National Pension Scheme, was introduced by Department of Economic Affairs, notification number such and such, dated 22/12/2003. It was provided that NPS would be mandatory for all new recruits to the central government service from 1st January 2004, except the armed forces. They have given practically the brief history, how the changes came. In this Department Office Memorandum of even number dated 26/7/2005, it was provided that all employees who joined the central government service or in the service of an autonomous body set up by the central government before 1/1/2004 and who were governed by old pension scheme under the Central Civil Service Pension Rules 1972 will continue to be governed by the same pension scheme rules and will count their past service if they take up new appointment in another ministry, department of the central government or a central autonomous body covered by CCS pension rules on or after 1/1/2004, subject to their satisfying the conditions laid down in para 4 of such and such OM number such and such dated 29/8/1984. Subsequently, while this department OM of even number dated 28/10/2009, the benefit of counting of past service under the CCS pension rules 1972 was extended to those employees who were initially appointed before 1/1/2004 in central government departments covered under the railway pension rules or other similar non-contributing pensionable establishment of central government covered by old pension scheme and rules under the CCS pension rules 1972, or 2. State government covered under old pension scheme similar to CCS pension rules or central stroke state autonomous body covered by old pension scheme and who resigned to join a central government department office or a central autonomous body having pensionable establishment. Representations have been received in this department from employees who joined under NPS in central government or central autonomous bodies after 1/1/2004 but before 28/10/2009. After technical resignation from a pensionable establishment of a central government department, state government or central stroke state autonomous body and who were denied the benefit of counting of past service in the old pension scheme in the central government. The matter has been examined, para 5, next page. The matter has been examined in consultation with Department of Personnel and Training and Department of Expenditure. It has been decided that those employees who joined the central government stroke central autonomous body under NPS during 1/1/2004 to 28/10/2009 after submitting technical resignation from central government stroke central autonomous body or a state government stroke state autonomous body and who fulfill the conditions for counting of past service in terms of this department OM dated 28/10/2009 may be given an option for induction in old pension scheme and to get their past services rendered in the central stroke state government or central stroke state autonomous body counted for the purpose of pensionary benefits on their final retirement from the central government stroke central autonomous body subject to fulfillment of all other conditions of counting of such past service in terms of such and such OM dated 29/8/84. Read with this department OM dated 7/2/86 as amended from time to time. Para 6 talks about option may be exercised within 3 months of the issue of this OM. So far as this exercise of the option is concerned, my lord will find, once I deal with the facts, my lord will find that Nehu took a plea that You did not exercise the option.
You come under central autonomous body. So you're fitting this memorandum.
My submission would be fit in the memorandum. My services, I will have two parts of my argument. Going by my conditions of service, going by the factum that I get my salary from the government of Bengal, going by the fact that disciplinary control over me is vested with the government of West Bengal, going by the fact that the government of West Bengal is vested with the power to transfer me also from one college to another, I would submit for all intent and purpose, basically, I was, my lord, more or less the government, I should be treated to be an employee of the government of West Bengal or of a state autonomous body. Because BSES is not a minority institution, it's not a minority religion. Ultimately, my lord will have to lift the veil and see what exactly it is. And in any case, my lord, my second argument would be on that. This office memorandum, what is the purpose behind the office memorandum? What is the objective? The objective behind the office memorandum is to ensure seamless mobility of the competent eligible employee from one institution to another. And when they move, they should not suffer any prejudice. It is for the benefit of the employees. Now, my lord, when it is a beneficial, I would call it beneficial.
We finished that part regarding, this college coming under the West Bengal government. Now, next part, you address the pension. I mean,
I'll deal with that. I'll deal with that.
Now we come to this.
Yes.
We come to that, yes.
Now, straight away, Lordship will turn to the first part of my compilation, the list of dates.
The earlier compilation.
The first one.
Yes, my lord.
The one which was shown by your lordship. The first one.
Okay. Let's come to that, yes.
My lord, my learned friend is very, very careful. He is whispering to me and saying that please make it clear that all the documents are part of the writ petition or the materials on record. We have given the cross references here itself. I'll be brief here. I will not read everything. 4/12/1997 is the first date.
Yes.
On recommendation of West Bengal College Service Commission and the Staff Selection Committee, Principal City College Calcutta issued an appointment letter to the petitioner appointing her as lecturer in zoology with request to join on 2/1/98. Cross references we have given. 2/1/98, petitioner joined the City College as lecturer of zoology by submitting a joining report. 26/2/98, petitioner opted for pension, including family pension cum gratuity. So, my lord, I opted for pension including family pension cum gratuity as per option form under para 2 of the government order number such and such dated 31/5/78. Now 31/5/78, my lord, will find annexure D, page 13 of the affidavit in a position of respondent 6. Now respondent 6 happens to be state of West Bengal. And my lord, here I have enclosed it, page 12 and enclosure 3.
Yes.
Page 12, lordship may have a look.
Pension including family pension.
Yes,
gratuity.
yes.
Yes.
Page 12 option form, my lord, this is of the government of West Bengal. Annexure D, pension including family pension cum gratuity, contributory provident fund is not there. It is GPF. This is it. Then, my lord, 16/2/99, in the meeting of the governing body of City College Calcutta, resolution was passed confirming the petitioner in service. 2/1/2007, petitioner was promoted to the post of reader. 20th March 2007, Nehu issued an offer of appointment to the petitioner for the post of reader in the Department of Zoology. Now, my lord, offer of appointment, there is something interesting. My lord may see clause 3 of the offer. Clause 3. Here, my lord, we have enclosed it. Yes, clause 3 of the offer. Here, my lord, we have enclosed it. It is page 15, internal. Page 15.
1/5.
Yes. Clause 3, that you will be entitled to retirement benefits as per university rules, and if you are not governed by CCS pension rule 72 under your previous employer, you will be governed by new pension scheme as applicable to the central government employee with effect from 1/1/2004. So, my lord, sum and substance of this clause is, if you are not governed by CCS pension rule 72 under your previous employer, then in that case you will be covered by NPS. Meaning thereby, if it is something similar to CCS 72, then I'll be governed by that. And my lord, the term used here is employer. And it will be the loaded question my lord will be answering, going by everything, my service in City College, Calcutta, who really was my employer? My lord, answer is obvious. Who was my employer? Now, my lord, I come to 28th March 2007. In a meeting of the governing body of City College, resolution was passed to release the petitioner on lien without pay for 2 years with effect from 19/4/2007 to join as a reader in Department of Zoology in Nehu. So, my lord, from 2nd January 98 to 19th April 2007, practically for 9 years, she served in City College, Calcutta. She joined Nehu on 19th April itself.
Yeah.
She joined Nehu. On 14/6/2007, Nehu issued an appointment order to the petitioner. Now, my lord, interestingly, in this appointment order, there is another clause 3. And lordship will find a clear departure from language. Clause 3. This, my lord, will find internal page 17. Internal page 17. That Dr. Bela Kesan will be entitled to retirement benefits as per new pension scheme. No rider, nothing, straight away. NPS. Applicable to the central government employee with effect from 1/1/2004. For admission to the new NPS, Dr. Bela Kesan is required to submit the form attest duly filled in triplicate to the undersigned immediately. So, my lord, no if, no but, nothing, direct, you are covered by NPS. They deviated from their own offer of appointment. Next date is 20th of June 2007. The petitioner submitted a representation. So naturally, my lord, when I got such an appointment order, I saw the clause 3, I submitted a representation. The petitioner submitted a representation to the Nehu, apprising them that her service in the previous institution was governed by old pension scheme, and as such, she is entitled to be governed under old pension scheme at Nehu. It is already annexed with the writ petition, my lord, I will skip it. Then 27th July 2007, letter dated 27th July 2007 was issued by the principal of City College informing the Nehu that the petitioner had been working with City College from 2nd January 98 and she is covered by death cum retirement benefit scheme. So principal took a clear stand that well, in City College she was covered by death cum retirement benefit scheme. Enclosure 10, page 19. I'll just read that, page 19 internal. Lordship may have a look. Yes. Last 4 lines. I am to inform you that Srimati Bela Kesan joined the college as lecturer in zoology on 2/1/98. After the appointment, her pay was fixed at such and such, in the scale such and such, UDC such and such. From the Director of Public Instruction, Government of West Bengal, Education Directorate, UGC section because covered such and such. She was under death cum retirement benefit scheme from a date of appointment. That is it. Then, my lord, 1/8/2007, letter was issued by Nehu informing the petitioner that as there is no documentary evidence to indicate that the petitioner was covered under GPF scheme, as such her case was considered under NPS. Further, the petitioner was directed to submit her last pay certificate so that Nehu can examine her case further. So, my lord, they said there is nothing to indicate that she was covered under GPF.
This is wrong.
My lord, ex facie, because Lordship has already seen that. That's why I have given the note. On the contrary, petitioner had a GPF account as mentioned in the certificate dated 15/5/23 of Principal City College, such and such. Same was under the notification of West Bengal government dated 28/6/93 and 28/6/1963. That also, my lord, we have annexed. That 28th of June 1963 notification of West Bengal government is annexed by the government of West Bengal in its affidavit. Lordship will find annexure H1 at page 19 of the affidavit. We have given the cross references. I will refer to it. So this is wrong. GPF is very much there, my lord. It is evident from the document. 18th August 2007, a letter was issued to the Deputy Registrar Nehu by the Principal of City College, wherein it was informed that the petitioner was covered under GPF scheme. It was clearly pointed out by the Principal. Now, my lord, one may say, well, he is the Principal only. Who would know better other than the Principal? that in what benefit petitioner was entitled to. Enclosure 12, page 21.
Yes.
Lordship may have a look. What principle says again? In compliance with your letter mentioned under reference, I am to state that Dr. Bela Kisan joined this college on 2/1/98 as lecturer in zoology. She was in the GPF scheme from the date of joining. A copy of last pay certificate is attached herewith. So, not both the conditions of Nehu were fulfilled. Nehu says, number one, not covered in the GPF. Number two, you give the last pay certificate. Principal sends the last pay certificate. Evidence is clear cut. Yes, she was covered by GPF. Then again Nehu will change. Repeatedly, my lord, Nehu is changing its stand. In this very case, my lord will notice. My lord, lest I sound repetitive, my lord, I am making it very clear. I am not seeking any relief from the government of West Bengal. Sometimes, my lord, I forget, I feel that my esteemed colleague is my adversary and not Mr. Suvir Sen, representing Nehu over here.
Yes.
Now, my lord, 24/9/2007, the Deputy Registrar Nehu issued a letter to the principal of City College seeking clarification with regard to whether the pensionary benefits would have been admissible to petitioner had she been retired from City College, and whether the said rules under which she would have been paid pension is mutatis mutandis or identical to CCS Pension Rules 1972. So now, my lord, they are indulging in hair splitting exercise. I will read this letter, page 22, enclosure 13. Two queries have been raised. What pensionary benefit would have been admissible to Dr. Bela Kisan had she retired from City College? Now, my lord, this answer is very clear. The document itself, my lord, has shown wherein I had filled up the option form, I opted for the pension. If Dr. Bela Kisan would have been paid pension, whether such pension would have been regulated under CCS Pension Rule 72. No, CCS Pension Rule, my lord, we all know very well, it is applicable only with regard to the central government employees. I ask myself a question, what about state autonomous bodies? Their CCS Pension Rule is not there. But yes, when old pension scheme regime was there was system similar to that. So, my lord, this query was made, and then the reply, 13th February 2008. In reply, the Principal City College, white letter dated 13th February 2008, informed Nehu that the petitioner was eligible for pension and she is governed under pension, including family pension. So, my lord, if she dies, those dependent on her would get the family pension. Governed under pension, including family pension, come gratuity scheme, and as such she would have been paid pension had she retired from City College, Calcutta, but denied any knowledge as to whether the pension, including family pension, come gratuity scheme is identical mutatis mutandis to CCS Pension Rules 1972. No, my lord, it is too much to ask for my principal. Forget principal, my lord, I can't answer this question. How do we know? What we have to see, my lord, is the broad spirit of the whole thing. You are getting a pension, you are covered by the pensionary benefit. You are covered by the GPF. You are entitled to family pension. Your dependents after you die. What more is needed? It is absolutely similar to CCS Pension Rule 1972. Then on 12th August 2008, resignation of the petitioner from City College with effect from 19/4/2007, my lord, it was accepted by the governing body. Because she was here in the Nehu for long, 2 years, that lien period was completed. 3/9/2008, meeting of the governing body of City College adopting a resolution towards accepting the resignation of the petitioner with effect from 19/4/2007. Then comes 21st July 2009. The Deputy Secretary to the Government of West Bengal issued a clarification to Nehu. This time, Deputy Secretary Government of West Bengal writes clarification to Nehu stating that pensionary benefits of the teachers of the non-government college affiliated to different universities under Government of West Bengal are guided by government order number such and such dated 31/5/78. Now, my lord, this very document, we annexed it with as Annexure 11 to the writ petition. Here, my lord, will find enclosure 17 at page 26. This I show, page 26. Enclosure 17. Lordship may have a look. communication of Deputy Secretary, Government of West Bengal, with reference to your letter number such and such on the above subject, I am directed to say that the pensionary benefits of the teachers of the non-government college affiliated to different universities under Government of West Bengal are guided by such and such dated 31/5/78, a copy of which is enclosed. The revised rules in the light of West Bengal services such and such rule 2009 is however yet to be published. And this, my lord, 31/5/78, Lordship may kindly see page 27 capital A. The same thing, option. Page 27 capital A. Earlier I had shown to my lord, another copy I have annexed here. Lordship will see the date here on top, towards the right, 31/5/78. This is it. It is in the format, my lord, of the option form, wherein I exercise the option, pension, including family pension cum gratuity. Whether my lord has seen it? Yes, 31/5/78. Giving the number they have given it. Paragraph 2 of the government order number such and such dated 31/5/78. Now, my lord, next date is 12th February 2010. 12th February 2010, the Assistant Secretary to the Government of West Bengal, in continuation of the earlier letter of the department dated 21st July 2009, also forwarded the copy of the order of the Government of West Bengal dated 31/5/78 for consideration of NEHU. My lord, I have already annexed it. The same 31/5/78. That order they also communicated to NEHU. This was by Assistant Secretary to the Government of West Bengal. Now comes, my lord, the first impugn order, 11/4/2011. This is challenged in the writ petition. It is impugned, my lord, we have marked it. NEHU, by letter dated 11/4/2011, informed the petitioner that her request to admit her in the GPF scheme of the university cannot be accepted, as the pension including family pension cum gratuity scheme adopted by West Bengal does not fall under the purview of CCS pension rules 1972. Without pausing here, I ask myself, on what basis they came to this conclusion? What is the basis? Merely by saying it doesn't come would not do. What material you are relying on? That is it. So non-disclosure. They are satisfied it doesn't come. Is there ipse dixi completely. Then 21/9/2020, Deputy Secretary UGC issued a circular to all the central universities, including a copy of the Government of India Office Memorandum dated 11/6/2020. My lord, this I have already read, Office Memorandum. Now UGC takes a stand on that. On mobility of personnel among central, state and autonomous bodies while working under pensionable establishment, and asks for a compliance of the central universities, suggesting that 3 months period for calling the options would count from the date of issue of these instructions from UGC. So, with effect, the 3 months period will have to be counted from 21/9/2020. The exercise of option in 3 months. Now, my lord, note here I have given the clarification. The Office Memorandum of the Government of India dated 11/6/2020 is enclosed at page 56 to 65 of the writ petition. It is there, my lord, in the third compilation. Now, NEHU in its affidavit in opposition at para 10, page 7, stated that it did not bring the circular of the registrar of UGC dated September 2020 to the notice of the petitioner, as it was of the opinion that the said circular is not relevant to the petitioner. Now, my lord, UGC said the period of 3 months will be counted effectively from 21/9/2020. Regarding the exercise of option in terms of the Office Memorandum of the Government of India dated 11/6/2020. Apparently, my lord,
para 3 of the memorandum.
My lord, yes, I'll just come to that. That is, yes, that is it, my lord, because in the memorandum itself, the 3 months period was given. Now, my lord, the UGC said, when the circular was issued by the UGC said you count 3 months period effectively from 21/9/2020. That is the date on which UGC issued the circular. I'll just read below UGC circular, page 29. Page 29 of this compilation.
Yes.
that is, the undersigned is directed to enclose the copy of the Department of Pension, Pensioner Welfare such and such dated 11/6/20 for compliance with the request that the provision of the said OM should not be relaxed or diluted at any cost. Now, my lord, I am sure my esteemed colleague Mr. Subir Sen will harp upon this sentence for compliance with the request that the provisions of the said OM should not be relaxed or diluted at any cost. So, I'm sure submission would be made before this honorable court that OM dated 11/6/2020 has to be read strictly. But my lord will kindly mark the language. A request comes from UGC that the provision of the said OM should not be relaxed or diluted. The modalities of accounting of the NPS may be refunded as per clause 9 of the DOPT OM dated 11/6/2020. Further, it is also requested that the 3 months period for calling the options would count from the date of issue of these instructions from UGC. So, my lord, 3 months effectively from 21/9/2020. Now, my lord, apparently petitioner could not exercise any option within the 3 months period from 21/9/2020. This was because the circular was never brought to the notice of the petitioner by the NEHU. It was sent to NEHU by the UGC, and NEHU has admitted this in all fairness in its affidavit in opposition at paragraph 10, page 7, where it said it did not bring the circular to the registrar of UGC dated September 2020 to the notice of the petitioner, as it was of the opinion that the said circular is not relevant to the petitioner. So now, my lord, 18/8/21, the representation of the petitioner, I come to 18/8/21. Petitioner requested NEHU to consider her application for counting of her past service and the mobility from NPS to old pension scheme in the light of recent UGC circular such and such with attached office memorandum such and such. In her letter, the petitioner also stated that as this UGC circular was not circulated by NEHU to its employees, she was unaware of this circular and thus could not apply within the stipulated time. This is what petitioner stated. 2/12/21, second impugned order, my lord, by NEHU. Next page. 2/12/21.
Yes.
NEHU issued a letter to the petitioner informing her that her application dated 18/8/21, that is, they are referring to the representation, the application, was re-examined and the earlier decision communicated in letter dated 11/4/2011 stands, thereby rejecting her request for mobility from NPS to old pension scheme on the basis of the decision dated 11/4/21. So they stuck to their decision that petitioner would be covered by NPS and they would not allow her the benefit of OPS. This we have impugned in the writ petition. Then 13/12/21, as the petitioner's application dated 18/8/21 was rejected by NEHU on 2/12/21, the petitioner again wrote a letter dated 13/12/21 to NEHU requesting NEHU to enlighten her whether her case fits into UGC number such and such dated 21/9/20 with attached office memorandum from Government of India such and such. Then, my lord, series of representations, we have given those references, various dates we have given. Then comes, my lord, the third order, which is also impugned, dated 31/8/22. 31/8/22. NEHU gave a reply to the petitioner on 31/8/22 informing her that her application for counting of past service was examined in light of office memorandum dated 11/6/20, and since she did not submit her application within the stipulated time, her application cannot be considered. Without pausing here, I submit this very reasoning of NEHU prima facie does not stand the legal scrutiny. Because by NEHU's own admission in its affidavit in opposition, we did not bring this to her notice because we felt that in any case she is not covered by it. Further, it was mentioned that it cannot be ascertained whether pension cum gratuity scheme was adopted by the government of West Bengal and is in operation in the City College, Calcutta, is similar to CCS Pension Rules 1972. To this, my lord, my submission is, what is the material to reach to this conclusion? On what basis? Merely because it is their subjective satisfaction. It is not similar. They could not ascertain it. If you could not ascertain it, that by itself could not be a reason that we are not governed by that. So note I have given, since the petitioner's application for mobility in the old pension scheme was not considered, her past service rendered at City College, Calcutta was also not counted for determining her pensionable service. Consequently, the petitioner's application for voluntary retirement was also not considered, as due to non-consideration of her past service in the City College, Calcutta, the petitioner was only having 15 years of completed service in NEHU and not the required 20 years of completed service to make her eligible for voluntary retirement. My lord knows very well. Unless and until I complete 20 years, I can't get the benefit of voluntary retirement. So, my lord, even if I go for voluntary retirement, my employer will say nothing doing, it's a resignation. Because you have not completed 20 years of service here in this institution. Because the service rendered by her in City College, they are not counting. And the second note, we have given that in any case, the stand of NEHU in its affidavit in opposition is different. They say we didn't bring it to her notice. Then, my lord, another representation, 2922 by the petitioner, I will skip it. Then comes the fourth impugn order, 6922. NEHU accepted petitioner's resignation but not her voluntary retirement. The reasons are obvious, because according to them, only 15 years are over, not 20 years at NEHU, without specifying as to which letter or representation of the petitioner was treated as a resignation. So, below, that's important. So, they treat this as a resignation. Now, which particular letter or petitioner they have treated as resignation? Because, below, in most of the representation, petitioner writes about the voluntary retirement. Of course, she has also used the word resignation at times in sheer frustration. She says, if you don't accept it, that's it. Because my mother is ill, I have to look after my mother. The lady actually, she is unmarried. She has a old mother to look after. So she had her problems. She was thoroughly fed up. Series of representations are there. So anyway, below, they do not refer to any particular representation or letter. They say this is a resignation, because in any case, you have completed only 15 years, not 20 years. 15/5/23, a certificate of self-declaration was issued by the Secretary Provident Fund Committee of the City College and the Principal of City College, containing details of petitioner's service in the City College and informing that the petitioner was subscriber of GPF, was maintained by the college under the special provision of the order of the Government of West Bengal dated 28th June 1963, and as per Provident Fund meeting dated 9/7/2016, her Provident Fund amount was finally disbursed. It was further stated that as per order number such and such dated 20th June 2017, the Provident Fund of both teaching and non-teaching staff of the college was transferred to the Government of West Bengal on 23/10/2018. Below, the relevant document also we have annexed. It is there on record. Below, anyway, this should not create any problem whatsoever, because below, I have been given to understand that in the event of my lord taking a favorable view, petitioner is willing to make good the loss. The whatever, whatever amount she will be required to pay in the GPF, she will pay.
Like in Dijan Sharma's case.
Like with the Dijan Sharma's case, my lord would remember, Lordship delivered a judgment. That was the case of provincialization, of course, from Assam. That Assam case, my lord. It was the provincialized college, and from provincialized college in Assam, he came to NEHU. So my lord delivered a judgment. So my lord directed in that case that for past, whatever contribution he has to make for the GPF, he will make good. He will make it good. So here also, my lord, she is willing to do that. So that should not create any problem. Now, my lord, for the convenience of this honorable court, I have made a separate compilation with under the heading basis of petitioner's entitlement. That is for the submitted. Yes, I have already given to your lordship. Very few dates are there. What is the basis on which we are saying that we are entitled to?
Yes.
Whether my lord has got it?
Yes.
Yes, that is there. Just below the relevant things I will just point out. First is 28th June 1963. By notification of the Government of West Bengal, the provisions of the PF Act 25 were made applicable to all teachers and employees of the City College, Calcutta, such and such. Then 11/5/76, letter of Deputy Secretary Government of West Bengal, Director of Public Instruction, explaining the decision of the Government of West Bengal in respect of pension scheme for the teachers of non-government affiliated colleges, including government-sponsored colleges. It was stated that teachers who opt for new UGC scale of pay as introduced in the department under such and such with condition test thereto should be given. One, either retirement benefit such as general provident fund cum pension cum gratuity as applicable to state government employees of corresponding rank and pay. The first one, my lord, is relevant. The first one. Because first one we opted for. 11,576. So, that line I have marked, the teachers being given option to choose either of the two. Either you go for contributory provident fund or retirement benefit such as GPF, come pension, come gratuity. Lordship has already seen, she opted for first one. Pension, come gratuity, come GPF. Then 31,578, Lordship has already seen it. This is another basis. Yes, already. Please. Lordship has already seen it. 31,578. Then 26,298, petitioner opted for pension, including family pension cum gratuity. Lordship has seen this also already. Yes. 26,298. 27th July 2007, letter of Principal City College to the NEHU stating that petitioner was serving in City College was covered by pension cum gratuity, including family pension. My lord has seen this also already in the earlier list of dates. 21/7/2009, letter of the Deputy Secretary Government of West Bengal to, I'm sorry, my lord, World Bengal is missing. To the Deputy Registrar NEHU stating that pensionary benefits of the teachers of the non-government college affiliated to different universities under Government of West Bengal are guided by such and such. Lordship has seen this also. 12th February 2010 forwarding letter. Assistant Secretary Government of West Bengal in continuation of the earlier letter dated 21/7/2009 forwarded the copy of the order. Lordship has seen this also. 31,578 he forwarded. 22/3/2017, that is, my lord, I have referred to this act. West Bengal Universities and College Administration and Regulation Act 2017. Lordship has seen this also. Then 15/5/23 is a certificate issued by Principal City College, countersigned by Secretary regarding the Provident Fund and all that. My lord has seen this also. The previous subscriber of GPF, etc. All this, we have given the cross reference. It is from the affidavit in opposition of the state of West Bengal. Annexure H, page 18. Cross reference I have given. Then 26/5/23 statutory declaration under the RTI by the Principal City College stating that the financial status of the City College is grant in aid and comes under general audit by statute such and such. My lord, not very relevant. So these are the things. So my lord, my submission is basically what is to be seen is who was the employer of the petitioner when she was serving in City College. That is the question we have to ask ourselves. And my lord, the answer is very clear. The employer is the person who has a power, who gives me salary. The employer is the person who has a power to transfer me from the college. The employer is a person who exercises the power of discipline over me. And my lord, for a proposition that finally, my lord, the office memorandum of the Government of India, Department of Pension, is a beneficial piece. My lord, we have to see this as a beneficial policy meant for the employees of the government. So, my lord, it is to be liberally construed. For that proposition, my lord, I will just cite two judgments. For a principle only, my lord, primarily, lordship is well familiar with this principle. I will not read. I will just, my lord, the first is, my lord, 1999, 6 SCC, page 459. Page 459. The relevant paragraphs are para 15, 16, 17 and 18. 15, para 15, 16, 17 and 18. The principle, my lord, has been, yes. Para 15 I just read, it is a duty of the court to interpret a provision, especially a beneficial provision, literally so as to give it a wider meaning rather than a restrictive meaning which would negate the very object of the rule. So we have to, after all, holistically we have to see. And my lord, I would submit it is not a case of black and white. It is, nobody can say, oh, 100% I am in a private institution, pure and simple. Maximum, my lord, even if we take all the factors into consideration, I would say I may be in a grey zone. If I am in a grey zone, my lord will liberally interpret it and would give me that benefit. The next is, my lord, for the same principle, it's a constitution bench, Union of India versus Pradeep Kumari, 1995, 2 SEC, page 736, relevant page is 742, paragraph 8. Para 8, my lord, in fact, the relevant portion, my lord, will find at Placitum A, page 742. Placitum A. Lordship will just see in relation to beneficent legislation, whether my lord has got it.
Yes.
Page 742.
Yeah.
Third line.
Yeah.
Just against Placitum A.
Yeah.
In relation to beneficent legislation, the law is well settled that while construing the provisions of such a legislation, the court should adopt a construction which advances the policy, etc., etc. So this is it, my lord. And my lord, the other thing, it is likely to be argued by my esteemed colleague Mr. Sen for Nehu that look, the UGC said very clearly in its communication, they may refer to UGC communication, that the office memorandum of the Government of India have to be, my lord, interpreted strictly. I am anticipating this, my lord, submission from them and I am answering it right now. I have got twofold argument on that.
Yes.
Firstly, my lord, UGC used the expression request. It's a request from UGC. You construe it liberally because UGC is not a competent authority. That's first part. It's a request. The word request is used. The second part is, my lord, UGC is not the author of the office memorandum of 2009, 2010, etc. It is Government of India Department of Pension. It is the concerned authority which issues or declares the policy, which can clarify its own policy or modify its own policy. It is not open for a third body to say how it is to be looked into or how it is to be read. UGC is not competent. So, my lord, on this principle, there are many judgments of the High Court. I could not lay my hand on any judgment of the Supreme Court, but referring to High Court, my lord, I could get certain observations from the division bench judgment from the Allahabad High Court. I'll just place that. This is 1989 SEC online, Allahabad 870. For principle. In any case, my lord, it stands to common sense. As my lord Denning says, law is not against common sense. UGC is not the author of those office memorandums. It is nobody to say how it is to be read. My lord will decide how it is to be read. Relevant para is para 7 and para 8. Here, my lord, on the name of the governor, the joint secretary, my lord, had issued certain directions. Para 7, my lord will see the history.
Yes.
And then, my lord, a lower authority, my lord, issued the clarification. Court said, no, this can't be done. Para 7 and para 8. The principle, my lord, I am only on the principle. In any case, no judgment is necessary for this. So, my lord, my submission is this. Lordship may be pleased to consider at least. At least Dehu has been very, they have been too technical in this aspect. And, my lord, my plea to my esteemed colleague appearing for the state of West Bengal would be, I am not seeking any relief against the state of West Bengal. The stand of the state of West Bengal is very clear in its affidavit in opposition. They have taken a very holistic view. They have been very fair with my past.
Yes.
They are very categorical about the nature of pensionary benefits I was entitled to while serving in the City College, Calcutta. And my lord, the legislations of the Government of West Bengal are very, very clear regarding the discipline, regarding the transfer, regarding the salary, regarding the retirement benefits, etc. So my submission is, my lord may treat me as an employee of the Government of West Bengal in letter and practically, my lord, basically in spirit, even if not in letter. I would submit here is a case of both letter and spirit for all intent and purpose. My lord would not be too technical, my lord, in looking into the nature of my work. Who am I? How am I bound? Whether I was entitled to Article 311 of the Constitution, whether that protection is available to me, whether I am holder of a civil post, etc., etc. Here, my lord, the nature of service. So that's my submission, my lord.
Yes.
And my lord has been very considerate. I have nothing more, my lord, subject to whatever falls from my esteemed colleague, Mr. Sen. I'll give a clarification.
We'll resume at 2.
Please, Your Lordship. Lordship, I'm seeking your indulgence, Lordship. Item number 24. If Your Lordship can take it up after 2 weeks.
My lord, I am about the petitioner, my lord. I am over it.
Highly obliged, Lordship.
My lord.
24.
Sorry.
My lord, at 2 p.m.
Yes.
Lordship, at 2 p.m.
Yes.
If I may be allowed to make my submission and leave, my lord, because I have to attend the Calcutta High Court.
You want to make submissions now?
No, at 2 p.m. I will not take more than 15-20 minutes.
Okay. Yes, of course.
May I please, Your Lordship? That's item number 15, Your Lordship.
Obliged, Your Lordship. Why?
Already. Let this matter come up next week, Your Lordship.
Why? Who's other side?
My lord, only thing Lordship asked me to verify from the attendance register. No, attendance register speaks for itself. Now, 2 attendance register of 2 writ petitioners. 1 writ petitioner, my lord, Saturday, Sunday never signed. So this is, my lord, highly disputed question of facts, my lord. Based on this, Lordship.
We will see it. Let's see. When?
Next week, Your Lordship.
Next week. Yes. 15.
Yes.
Obliged.
Much obliged.
Yes.
May it please, Your Lordship. Your Lordship's item number 14,
yes.
23 and 25. Your Lordship, Mr. Shulai will be engaged in the division bench, which is still single bench is sitting, Your Lordship, and then the DB will be sitting.
Since CG is retiring also in 2-3 days time, better give him full attention.
Yes, Your Lordship.
Yes. Yes, at 2. Reply. You'll finish today?
Yes. But I'll make it very short.
Obliged, Your Lordship.
Lots my senior will be joining from BC.
Yes. Yes.
So far as responding number 6 and 7 is concerned,
Yes.
state of West Bengal, one of the affidavit on behalf of the state Bengal, on behalf of the state of West Bengal has clearly mentioned everything, but one aspect has to be considered. That is the appointment of the petitioner. The appointment order was issued in the year 1997 and she was appointed in the year 1998.
Yes.
Thereafter, my lord, she was on leave for 2 years and it is a fact that she resigned from City College and joined NEHU in the year 2007. If you can take the lordship to the affidavit in opposition of the state of West Bengal, respondent number 6.
Yes.
Lord, kindly come to page 16, madam, NFTG.
File by respondent number 6. Okay.
Lordship,
By 6, right? 1 second.
page 16. Page 16, annexure G. Opposition to state of West Bengal.
6, the respondent number 6. Huh? Number 6 either. 1 second. 111. Page 16.
Page 16, NFCG.
Yes.
This is a resignation. Resignation from the post of leader in Zoology City College, Kolkata.
Yes.
Effective from 19th April 2007.
Yes.
This is to inform you that I am today submitting my resignation of employment from the post of the leader in Zoology from your college, which will become effective from 19th April 2007 and thus cancelling my leave period, which was for 2 years, effective from 19th April 2007. I have made this decision in the best interest of my career as my appointment as a leader in the Department of Zoology at Northeastern Hill University stands confirmed with effect from 19th April 2007.
Yes.
Now, the question which will come up for consideration of your lordship is that it will be a continuation of our previous service or not.
Right.
Whether it should be considered as a new appointment.
Yes.
If she has resigned from her earlier service
Yes.
and she was appointed on 19th of April 2007, the question to be decided by your lordship is whether it will be a continuation of her earlier service or not. That is the moment. Secondly, my lord, if I can take your lordship to page 17, paragraph 20 of this petition.
Excuse me.
I am just placing the facts, my lord.
Yes, yes. Page 17.
Page 17, paragraph 20.
Yes.
Paragraph 20, your lordship has got it.
Yes.
That after submitting the aforesaid representations, the petitioner was expecting a favorable response from NEHU. However, on 31st August 2022, the respondent authority informed the petitioner that in the office memorandum dated 11/6/2020 regarding mobility of personnel amongst central, state and autonomous bodies while working under pensionable service under the Ministry of Personnel, Public Grievances and Pensions in the Department of Pension and Pensioners Welfare, it has been stated that an option of induction of old pension scheme is to be exercised by the employee within 3 months from the issuance of the memorandum.
Yes.
And that as the petitioner had given a representation after 14 months, therefore the respondent university had denied the benefits to the petitioner with regard to voluntary retirement. It was also informed that as the petitioner had not completed the requisite years, as required to avail the voluntary retirement, therefore the petitioner could not be considered the benefits under the voluntary retirement. This scheme, for availing the old pension scheme, the petitioner had to submit a representation or an application before the authorities within a period of 3 months, which admittedly she has done after a period of 14 months. And therefore, the denial of the old pension scheme. Well, it's a fact that when she joined the city college, she was under the old pension scheme.
Yes.
But if your lordship kindly come to page, you can take your lordship to page 56.
Of the petition.
Of the petition. 56, in fact, 56 is the office memorandum of the 11th June 2020,
yes,
which my learned friend has already pointed out. But I would like to take your lordship to paragraph 5, 6 and 7 only. That is at page 57, my lord.
Yes.
The matter has been examined in consultation with the Department of Personnel and Training and Department of Expenditure. It has been decided that those employees who joined central government, central autonomous body under NPS during 1/1/2004 to 28th of October 2009, after submitting technical resignation from central government, central autonomous body, or a state government, or state autonomous body, and to fulfill the conditions for counting of past service in terms of this department's OM dated 28th October 2009, may be given an option for induction in old pension scheme and to get their past service rendered in the central state government or central state autonomous body counted for the purpose of pensionary benefits on their final retirement from the central government, central autonomous body, subject to fulfillment of all other conditions of counting of such past service in terms of DPNAR's OM dated 28th August 1984, met with this department's OM dated 7th February 1986, as amended from time to time. Paragraph 6. Such option may be exercised. But here comes the issue which is involved in this particular issue. That the petitioner failed to avail this particular option, and that is the reason that she was denied of the opportunity of old pension scheme. Such option may be exercised within 3 months of the issue of this OM. Such employees who are appointed under NPS, that is the new pension scheme, during 1/1/2004 to 28th October 2009, the fact remains whether the petitioner was appointed in the year 2007, that is within this period, when the new pension scheme under NPS during 1st of January 2004 to 28th of October 2009 are eligible to exercise option in terms of applicable above, but do not exercise the option within the stipulated period, will continue to be covered by the provisions of National Pension Scheme. That is the new pension scheme. if they do not avail this opportunity, those employees will continue to be covered by the provisions of National Pension Scheme. Benefit of CCS pension rules in terms of OM dated 28th of October 2009 will continue to be governed by those rules. This makes it clear the issue which is involved. That first of all, that whether there was a continuation of the service of the petitioner, or whether there was any break. The fact remains there was a break. She resigned.
Yes.
Her resignation accepted, and she was appointed afresh as a reader in name. Secondly, whether she availed the opportunity of the new pension scheme. It is an admitted fact in the writ petition, my lord, which I pointed out before your lordship just now, in page 20, para 17, she has admitted that it was, the application was submitted after 14 months, which is related to the provision of this memorandum, paragraph 5 and 6, which I pointed out. So this is the core issue, my lord. This is the only core issue, that whether it is a continuation of service and whether it was done on time or not. Whether the Supreme Court in several judgments and orders have repeatedly said that when it will miss the bus, it is the bus. I have just placed the facts before you, lordship.
Yes.
It is up to your lordship to decide that whether this should be treated as a continuation of a service or whether a break in a service, and whether
yes,
submitting the representation after 14 months, that can be, that particular provision in this claim can be made or not. But just take one order which was, this is not a reported judgment but an order which was passed in a writ petition civil number 98 by the Red Junior will submit this, that in this matter, my lord, petitioner failing to upload a one-time password OTP within the stipulated time at the institution for confirmation of admission. Hence, no case of interference under Article 32 of the Constitution is laid out, and the petitioner is dismissed. The petitioner has need to provide this particular OTP on time. So if you miss to provide the same within the stipulated time, it cannot be entertained. This particular principle is clearly covered
yes,
in points which I have raised just now before your lordship. And this is a very short point to be considered by your lordship.
yes. That's it.
That's all.
Thank you.
That's it.
Yes.
And deeply obliged. Your lordship, kindly.
Yes, please. Yes.
Can you permit it?
Yes, please.
I am obliged.
Thank you.
May it please your lordships.
No matter.
The admitted fact is this in this case, your lordships, with effect from 1/1/2004, my lord, the new pension scheme came into force. And the old pension has been done away with. Now, my lord, following this, my lord, starting from 2005, a series of notifications, my lord will take note, notifications, not legislations. Notifications were issued. Now, first notification, my lord, the issue, my lord, with regard to mobility from central government to central government was addressed. They have taken a decision, my lord, personal administration taken a decision that those who were in the service of the central government prior to, my lord, 1/1/2004, and if they, my lord, switch over to another department of the central governments and subsequently tender technical resignations, their service in the previous department would be counted. First, it was confined to central government provided they were enjoying similar pension as under CCS. Subsequently, it has been further expanded. Scope has been further expanded, my lord. They have brought in movement from state governments to central government. That was included in similar line. Then they have also included, my lord, autonomous bodies set up either by the, my lord, central government or the state government. So, ambit of all these notification, my lord, starting from 2005, 6 and 11, your lordships, what they have included, my lord, central government to central government, one department to another department, state government to, my lord, central government, autonomous body, my lord, set up either by the state or by the central government to central government. Now, these are the, my lord, three clearly defined situation, my lord, under which, my lord, this past service could be counted, not otherwise. So here is a case what my learned friend is trying, my lord, and in fact my learned friend has admitted this is a grey zone, asking your lordship, my lord, perhaps to expand the scope of this notification. My humble submission, your lordships, there is no scope for expanding these notifications. Now, my lord, in this block, this is the crux of the issue, my lord. Now I'll satisfy, my lord, what is the status of this college. If your lordship kindly look into my affidavit. Now, admittedly, my lord, this is a non-government college administered by a managing committee.
Yes.
Receiving aid from the
government.
And there are some kind of pension schemes, my lord, which was given to them. No way in this, I'll take my lord to those notifications issued from time to time, my lord, in 5, 6 and 2011. No way, my lord, there is even by implication, there is a reference that any other an employee working in any other entity which are under the effective control of either the state or central government, they have not mentioned, your lordships. They are very clear and categorical. Central, autonomous body, state. Nothing else. Now, my learned friend took a long time, my lord, making a submission, my lord, regarding the service condition and other things, my lord. Those, my lord, that maybe your lordship would be appropriate while making a submission, my lord, and forcing a writ, my lord, to my lord, justify, my lord, an entity comes within the instrumentality of state, your lordships, defined in Article 12. But not in this case, my lord. When the notification is very clear and categorical, lordship cannot include an entity like the city college, whether, my lord, they are getting pension immaterial.
Yes.
Now, my lord, what happened in 2020? Now, that is the issue because my learned friend, senior friend has placed before my lords. We have made a categorical statement that this is 2020, what happened, your lordship. Now, my lord, a fresh notification has come. A fresh notification, what it said that those who are joined, my lord, between 1/1/2004 and 2009, if they exercise their option, provided they are eligible, then they should be allowed to exercise such option within a stipulated period of 3 months. So that is my humble suggestion. This is not very relevant for deciding this case. Because with reference to those earlier, because 2020, if my lord look into, 2020 is, they have summed up, my lord, all those previous notifications, nothing new here. Center to center, your lordships, autonomous body to central government, state government to central, same, they have referred to earlier notifications and they have given a chance those who have missed out. So far the writ petitioner is concerned, your lordship, her case was considered after detailed inquiry. We have made formal communication to the city college. And her case was determined with reference to those relevant mobility notifications. We have answered in 2009. Matters stand closed. So this 2020 notification is not going to help her. This is a futile exercise, my lord. Even if she had, it was known to her, and even she had exercised this option within that stipulated time, my lord, would have been rejected. But she has to be eligible, my lord, as per the terms of the notifications. Now, my lord, if I can take my lords to page 13
of the writ petition
of my affidavit filed by the respondent number 1, 2 and 3. Page 14, my lord. The relevant part is at page 14.
14.
14, 1-4. Under chapter 2, definitions. In the schemes, unless there is anything repugnant to the subject context, affiliated means recognized universities.
1 second.
Lordship has got it. Page 14, my lord, of my affidavit.
Yes.
Lordship.
14. This is that page like this.
Yes, my lord, folded, I'm sorry.
Which part is it?
Chapter 2, my lord, definitions.
Okay.
In the bottom. In this scheme, unless there is anything repugnant to the subject context, affiliated means recognized by the universities in West Bengal. B. College means a college or an institution having all or any of the streams, arts, science, commerce, education, which is affiliated to the university in accordance with the provision of the Act, constituting such university statute ordinance does not include a college established, maintained, and administered by the state government. Now, where I am referring to this decision, this scheme has clearly classified. There is a set of colleges which are non-government colleges. They do not stand at par with the government colleges.
Yes.
Now, this is the scheme for non-government college. So, it clearly distinguishes, my lord, that they stand apart from the government colleges. They are not government colleges. And my humble submission, my lord, when admittedly, my lord, that scheme is saying they are not government colleges, only because state control, fund, their condition of service is governed by the state, my lord, will not bring them within the ambit of state. So far, my lord, these notifications are concerned. Now, if I can take my lords briefly to paragraph 7, it's not a very long, paragraph 7 of my writ petition, of my affidavit, sorry. That with regard to the statement made in paragraph 6 of the writ petition, the answering respondent back to state that Balakisan joined the respondent university as a resident in the Department of Geology on 19/4/2007. As per the directive of the Government of India, the employees appointed on or after 1/1/2000 shall be governed under the new pension scheme unless his or her previous employment is governed by the CCS. Hence, when the university had received the communication dated from the petitioner praying for induction into the old pension scheme on the ground that her previous employment at City College was governed by the UGC and the state government rules, the university, after examining her case and considering that the petitioner admittedly does not write account in such absence, her case could not be considered for CCH pension rules, and the same was communicated to the petitioner by letter dated 1/8/2007. Now, this is, my lord, regarding GPF. They say subsequently an account was opened. Admittedly, my lord, what happened, your lordship? When somebody applies, my lord, through my lord, proper channel and join a new establishment, my lord, on, my lord, the date she is confirmed, your lordship, and she render her technical resignation, your lordship, this is transfer. This has never happened here. But the GPF is, my lord, I am saying this is not the only criteria. Criteria is this: is it is a state government college? Perhaps it is a government college. Lordship has already exercised, my lord, looked into the law in that the one case, my lord, Sam Sharma, your lordship, versus the university. They are admittedly, my lord, the case of provincialization. Government has taken over the college from well before, my lord, 1/1/2004, and he was serving into that college. So in that situation, my lord has held that he is entitled for counting his past service. Now, if I can take, my lord, to the next paragraph, also relevant, that with regard to the statement made in paragraph 7, 8, and 9 of the writ petition, the answering respondent beg to state that the officer memorandum, as mentioned in the preceding paragraph, does not include the service of the employees of non-government colleges for counting past service. Nevertheless, the university, to verify and ascertain the eligibility of the petitioner to be covered under CCS Rule 1972 by letter dated such and such, has sought for clarification from the principal of City College, Calcutta. In reply, the university queries, principal by letter dated such and such, had categorically clarified that as per the order of the government of West Bengal dated such and such, petitioner service in City College, Calcutta was governed by West Bengal non-government college teachers death cum retirement benefit. Lordship will look into the nomenclatures, Your Lordship. Clearly saying the Act has defined, my Lord, they stand apart from the government college and is entitled to pension and retirement benefits such as General Provident Fund cum pension cum gratuity under the scheme. However, they have no knowledge whether the said scheme is similar akin to the CCS pension scheme. Thereafter, the Deputy Secretary, Assistant Secretary, Government of West Bengal Education Department, such and such, furnishing the reply has enclosed. This is clarified that the pensionary benefit to the teacher of the non-government colleges are governed and guided by said order scheme. As per the order of the scheme introduced in such and such, the same is applicable to the teacher affiliated to college as laid down in paragraph. It is further contemplated that separate instructions will follow regarding the opening of General Provident Fund accounts in respect of the said teachers who will exercise their option for pension cum gratuity, including this scheme. Even though the scheme speaks about GPF, admittedly petitioner does not have a GPF account. Further, the non-government college as examined by the university is different from CCS pension rules, and most importantly, the non-government college doesn't come within the guidelines of the office memorandum mentioned above. This being so, the university could not consider the case of the petitioner under CCS rule. So, my lord, what I want to convey here, the main reason, main thrust why we could not place her, my lord, into the old pension scheme, which was decided way back in 2009, your lordship. That's why we are saying 2020, this is irrelevant. With 2020 categorically say, those who join within this period, if they are eligible, they has to be eligible. They come within the ambit of state, autonomous or central. She doesn't fulfill any one of them, my lord. So it was already considered. So even if we had not issued, my lord, this circular to her, and now, my lord, that delay and it will not make any difference. Now, my lord, coming to the UGC. Now, my lord, UGC has also, my lord, is fully aware, my lord. These are all, my lord, central government notifications. They are issued from time to time. As I say, my lord, university is not a central government department, my lord. This is a statutory body, my lord. And central university, my lord, they are under strict regulation, my lord. Our sponsoring authority is the UGC. Now, UGC has been set up by an act of the parliament. And that categorically say, my lord, what is the service conditions and other thing that will be prescribed only by the UGC. Now, my learned senior friends, they are nobody. That's not correct, your lordship. It is the UGC, my lord. If UGC, my lord, dictate us, my lord, do certain things in a certain way, we are bound to do it. Now, UGC in its regulation, my lord, in its forwarding letter also, my lord, made it categorically, my lord, while, my lord, implementing these notifications, while they have extended implementing this mobility notification, my lord, we should not make any relaxation. We do not have any power to make any relaxation. And admittedly, my lord, this is a case, my lord, do not fall within the ambit of this central government, autonomous body setup, and the state. Now, my lord, regarding, my lord, the decision, my lord, what I had, all these submission, my lord, these relate to Supreme Court decision. These are all relates to, my lord, welfare legislation. Here we are not concerned with the legislation, my lord. Here we are concerned with certain executive instruction issued. They have issued certain executive instruction, my lord. My humble submission, my lord, REIT code will not expand it, because that will open a Pandora box. Because there are, my lord, numerous other organizations who are some way or other controlled by the government. They will also, my lord, seek some duty. So my humble submission, my lord, it is material, my lord, in 2020 where the fresh consideration was done, because 2020 is nothing, my lord, but the reproduction of earlier notification. She is not eligible. Not being eligible, my lord, that has been refused to her. Now, other aspect your lordship will look into. She has filed this case in 2023 and she resigned from the service, my lord. She has never challenged that. She has resigned. That was accepted by the university in 2022. So after her employer-employee relation terminated in 2020, she has filed this case. So, my lord, my humble submission, my lord, the crux of the issue here is this notifications. My lord, if she comes within, my lord, state, where the my lord, the scheme of the West Bengal is saying this is a non-government, stand in a different footing from the government colleges, my lord. If she comes, she succeeds. But my humble submission, my lord, there is no scope to expand it. So, my lord, this is not a case where your lordship will grant any relief.
Thank you.
5 minutes only. 5 minutes. I begin with, my lord, the submissions of the learned counsel for the state of West Bengal.
The only relevant part of his submission is that yes, City College, the petitioner was covered by OPS. That is the only relevant part. The rest of the things have no relevance whatsoever. Even then, my lord, I'll touch upon two aspects. First of all, he talks about the resignation. Petitioner resigned. With the resignation of the petitioner, there is a breakdown of the relationship. The vinculum juris operated. She is no longer the employee. Possibly, my lord, my esteemed colleague is not familiar with the concept of tactical resignation. What is tactical resignation? Because the petitioner joined Nehu.
On lien.
On lien. She joined Nehu on lien. That too, her joining on lien is 19th April 2007.
Yes. Technical resignation is on 2009.
Yes. And the lien was given to her on 28th of March. Lordship has seen those dates. Technical resignation, the entire principle has been explained in page 86 of the writ petition. We have annexed that Master Circular of the Government of India. I did not know. Lordship is familiar with all the principles. The second argument is option of 3 months not exercised. This has been answered by my esteemed colleague, that all that has no relevance whatsoever in this case. Even then, my lord, I clarify. In fact, the first time petitioner spoke about these things was on 20th June 2007. 20 June 2007, because when the appointment order was issued to her on 14th June 2007, Nehu issued appointment order to the petitioner on 14 June 2007. Prior to that, she had already joined Nehu on 19th April. Offer of appointment spoke about OPS and NPS. The moment she saw the departure in the order of appointment, she wrote to the Nehu on 20th June 2007, saying that no, I am covered by OPS. Lordship will see that. 20 June 2007 is the date in my compilation. It's a detailed representation. Petitioner says by representation dated 20 June 2007 that she is covered by OPS, supported by the London Council for the State of West Bengal. That is, my lord, enclosure 9, page 80. So, my lord, that answers the question. Nothing, and in any case, my lord, 3-month option would not come if we take into consideration the circular of the UGC of 2020. The Nehu very fairly said he never brought this to the notice of the petitioner because we believed that she is not entitled to this benefit. So, my lord, that answers the question. Now, my lord, I'll come to the submissions of my esteemed colleague. First submission is straight cut, my lord. He has hit the bullseye, which I was expecting from him. I am not eligible, in fact. He says I am not eligible by under the office memorandum because it talks about central government, state government employees, and the autonomous bodies of central and state. I ask myself, if a question is asked to us as to what is City College, is it an instrumentality of the state with the meaning of Article 12? The answer is affirmative, yes. All the ingredients of a state within the meaning of Article 12 is present here in respect of the City College. Now, my lord, I ask myself another question. What is an autonomous body? In the legal scheme of things, an autonomous body is an instrumentality of a state within the meaning of Article 12. Yes. So, therefore, City College falls into the category of the autonomous body of the state government because of the peculiar nature and the kind of the rules and the regulations that have been enforced by the state of West Bengal. That answers the question. It is an autonomous body under the deep and pervasive control of the state of West Bengal. This is the expression I will use, quote unquote. Again, my lord, I repeat, City College is an autonomous body and therefore an instrumentality of the state within the meaning of Article 12 because as an autonomous body, it is under deep and pervasive control of the state of West Bengal. And the employer of the petitioner was the government of West Bengal.
Yes.
Because her appointment, stroke recruitment, followed by discipline and control, 3 salary, 4 transfer. What else is left in the service? Everything is controlled by the state of West Bengal. Then, my lord, comes the second submission, that the death cum retirement benefit scheme is not applicable to the government college of the state. Ingenious submission, but the submission, my lord, simply, my lord, will not succeed for the simple reason. It is true that in the scheme of the death cum retirement benefit, it is mentioned that this very particular scheme does not cover the government colleges. It says so.
Government aided colleges.
Yes, yes. It says so, government colleges. That means death cum retirement benefit scheme is applicable in respect of government aided colleges. I accept it. Issue is not that. The issue is whether it is in the nature of OPS. And the Council for the State of West Bengal says yes, it is OPS. Number one, it is OPS. And number two, the city college is an instrumentality of the state and therefore an autonomous body. So, my lord, as to the very factum, the death cum retirement benefit scheme does not take within its fold the government colleges of the state of West Bengal is neither here nor there. Government colleges, naturally, their nature is different because they are created from the very inception by the government of West Bengal. From the very inception of the colleges are the government colleges. Everything is of the government, building, etc., everything. In the case of the aided colleges, the building may be constructed by X, maybe a private body. But in course of time, control. Yes, in course of time, my lord, the color may change. The issue is when I entered the city college as a teacher, what was my conditions of service and who was my employer? How I came into the service? What were the conditions of service I was governed? That is a relevant issue. So that answer, my lord, nothing else suffices. Grateful, my lord, nothing else. That's all.
You give one page bullet points just for yes.
My lord, from Guwahati it will be sent.
Just one page, just correlate with your notes.
There is nobody here, I don't know.
Yes,
Lord,
one page.
All the two things.
Here.
Compilation, I think that will be enough, my lord.
Should be, I think, yes.
This will be enough, my lord. Lordship is obliged, my lord.
Obliged, my lord. I think we'll reserve
Lord, I'm relieved and I'm grateful to my lord for patient hearing.
Thank you.
It was an albatross round my neck, this very particular case. I was harassed.
So you've discharged your obligation.
No, not my esteemed colleague, the other side.
Discharge your obligation. Yes.